Courtroom 2, good morning.
Good morning, Your Honor.
These haven't changed the law.
Morning, Your Honor.
Good morning. Morning. All right. Who are the PDs in courtroom 2?
Vigiletti and McLean.
Okay, are they talking? Oh, they're there. All right. Good morning, Ms. Vigiletti. I was just wondering where everyone was. How are you?
Good, how are you?
Doing well, thank you. Okay, good morning, ladies and gentlemen. My name is Judge Lal, and this is going to be the state all-purpose calendar with the State Court of Fulton County. These are misdemeanor cases in which individuals have already been accused of one or more misdemeanor offense. They've had their initial appearance, bonds have been set, and today we are going to address each case to determine the status of the how the defendant plans to move forward. When I call each case, the attorneys, the public defense counsel or private counsel will advise me as to whether they intend to have the case arraigned. In other words, the defendant would enter a plea of not guilty and have the case further scheduled for trial, or whether they intend to accept a recommendation from the prosecutor and enter into a plea hearing. Other matters that we may be addressing are probation revocations, bond modifications, as well as a competency calendar. If you're a defendant charged with one or more misdemeanor offense, please remember that you have a right to remain silent. Anything that you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you.
I'm sorry.
All right, Mr. McLean, good morning, sir. And who do you have for us today?
Well, let's see. I've got number 4, Mr. Barnes, start off in numerical order.
All right, is he
Is
in
he-
courtroom 2 with you?
He may be showing up on because of the floor. He might be showing up on Zoom later on. I
Okay,
also have Mr. Dumas is next, 13-14. I have Mr. Greer, 15-16.
all right. Let me check with the private counsel, Mr. Dennis Murphy. Good morning, sir. Who's your client on SAP?
Judge, I'm here for revocation hearing on Miss Jaslyn Fay.
All right, is Jasmine Fay in courtroom 2? No?
No, she'll be joined by ACDC.
All right. Please hold, Mr. Murphy. Mr. Shaw, good morning.
Good morning, Your Honor.
And who do you have?
I have Mr. Middleton.
Is Middleton in courtroom 2?
Yes,
He
Your
is.
Honor.
All right, maybe address him, please.
Middleton.
Is that a probation revocation or a,
It is 18 and 19.
all right, thank you, sir.
So,
Yes, this is positions 18 and 19. Just 1 second, I'll get to that. Oh, there we go. Thank you. All right, Vincent Middleton has 2 separate cases. First one is 21 CR 2132J, in which he's accused of battery family violence from March 22nd, 2021. And second case is 20 CR 377J, in which he's accused of simple battery family violence from August 22nd, 2019. Mr. Shaw, your client has been advised of his right to remain silent. How would we like to proceed today?
Your Honor, I just received the state's offer literally just moments before you got on the bench, Your Honor.
Mhm.
So is there a way for me to be placed in a breakout room with Mr. Middleton? Otherwise, I would need some time to convey the offer that I received to Mr. Middleton.
All right, let me see.
He can call courtroom 2.
All right, Mr. Shaw, if you'll call 404-613-292.
Got it.
No, that's not the right number. 404-613-2392.
Thank you, Your Honor. I have them all written down, so
Okay, was that the correct number?
I'll look it up right now.
Okay.
392 is the first one.
Thank you, Your Honor. I'll be back before you momentarily.
All right, thank you. Mr. Middleton, your attorney will be calling you while you're in the while you're in courtroom 2.
Yes, ma'am.
I'll let the deputy let you know where you need to be seated. In the meantime, maybe deputy, you may call whoever's in the courtroom right now. We can get started.
We can go to 13 and 14.
Thank you.
Mr. Boss.
Okay. For position 13 and 14, we have Reynard Dumas. And Mr. Dumas, position 13 is case 22 CR 4841J, in which he's been cited with 6 misdemeanor traffic offenses, including driving while license suspended, equipment violation, no proof of insurance, and driving without a proper commercial driver's license. And the second case is a bench warrant for failure to appear, 24 FTA 513. Mr. Dumas, you've been advised of your right to remain silent, and your attorney is Mr. McLean. This is going to be a non-negotiated plea. Is that still the status, Mr. McLean?
Correct, Your Honor.
All right. Ms. DeCiano, good morning.
Good
May
morning, Your Honor.
Have the state's recommendation.
Yes, Judge. On count 1, driving while license suspended, the recommendation is 12 months probation, served 20 days, credit for time served 10 days. That'll be from May 7th to May 8th of 2019, and then May 2nd, 2024 to today. Balance probated, a $2,500 fine, and a 1-year license suspension. On count 2, the headlight violation, 12 months probation concurrent with count 1, $265 fine. On count 3, the expired tag, 12 months probation concurrent with count 1, and a $135 fine. Count 4, giving false info to law enforcement, 12 months probation concurrent with count 1. Count 5, no proof of insurance, 12 months probation concurrent with count 1, and a $350 fine. And lastly, count 6, driving without a commercial vehicle without a CDL. That's going to be 12 months probation concurrent with count 1 and a $210 fine.
All right. Mr. McLean, what is what's the defense's position?
Your Honor, the only reason it's an unnegotiated or non-negotiated plea is he was concerned about the 1-year license suspension. His point is that this has been a while. Let's see, what's the date? It's been a while, and he's wondering if there's any way that the court can fashion an order that does not include a new license suspension because he needs to get to work.
Ms. Tyson?
The second point I would make, which was partially a concern of his, the main thing with license suspension is, are any of these MHAN? I saw at one point, I thought I saw a $2,500 fine, and if one of these is an MHAN, that allows the fine to be up to $5,000 instead of $1,000, but otherwise not.
Right. Well, I did let Ms. DeCiano allocate the factual basis for that particular plea offer. So why don't you go ahead, Ms. DeCiano?
Sure, Your Honor. This incident occurred on May 2nd, 2019. Officers were conducting a traffic enforcement in the area of Campbellton Road and Fairburn Road when they observed a white 18-wheeler driving with only one headlight. The officer initiated a stop on the vehicle, pulled the vehicle over, and noticed there was no license plate either. The officer made contact with the driver, who advised why he pulled him over, requested his license. The driver advised that he didn't have his license, but wrote down his name and date of birth and gave it to the officer. The officer checked through the Omnix system and quickly confirmed that the name that he gave was not the same person because the picture did not match. So he went back to the driver, asked to give him his real name and date of birth, and the driver gave him his real name and date of birth. It was the defendant. And he ran his license, determined that he had a suspended Class C license, and that he had 3 active warrants, 1 out of the State Board of Pardons and Parole, 1 out of Meriwether, and 1 out of Fulton County. In regards to the vehicle, Judge, they confirmed the vehicle came back with no registration at all. There was no insurance information either. And that's the basis for the plea. And just, Your Honor, the fine is what it is because he has 3 prior convictions and 5. He may have 4, but I can't see the disposition.
All right, thank you.
Matthew?
Ms. Tyson? I don't know if Ms. Tyson, yes.
Yes, I'm here. Yes, Your Honor. So I don't have a driving history. I just have a criminal history, and it kind of speaks to what Ms. Desiano said already. He has at least 4 driving while license suspended or revoked convictions, and that's just within the last 10 years.
Okay, that's good.
He's got,
Thank you.
yeah, he has a total of 38 cycles. So
Understood. Thank you. Yes, Mr. McLean, given his record with regards to operating a vehicle without proper licenses, and given the factual basis as allocated by the state, there is no particular option other for the fine as offered by the state and a mandatory 1-year suspension of a driver's license. He'll be required, and he will not be granted a limited driving permit. He would need to find an alternative means of getting transported. But him driving is definitely off the books.
Your Honor, may I go on mute and discuss this? for a
You may.
moment?
ACDC, which cases do you have there, please?
Good morning, Judge Law.
Good morning.
I have on the SAP calendar, position 27,
Mhm.
and on the probation calendar, I have 1 and 2, which is Carlton 1, 3 through 4, which is Faye, and 9 and 10, which is Tittle.
Bay at 9 and 10. Mr. Murphy, were those one of Mr. Murphy's cases?
Judge, yeah, Miss Fay was mine.
All right. While we're waiting for Mr. McLean, ACDC, good.
Judge,
Yeah.
yes. Now I was saying yes. I was answering you yes.
Okay. I'm going to take Ms. Fay right now. This is, good morning, Ms. Fay. My name is Judge Law, and we are addressing a probation revocation with regards to your case, to your matter. Please remember that you have a right to remain silent, and anything you say during the course of this proceeding, your statements can and will be used against you. You have a right to an attorney, and representing you is going to be Mr. Dennis Murphy. Do you see your attorney on the screen?
Yes, I do.
All right, thank you. This is a probation revocation matter, State versus Jaslyn Fay, case 22 CR 0047994G, in which Ms. Fay was convicted of battery, family violence. Her probation revocation case number is 24 PV 749. Officer Allen is with the Fulton County Probation. And Ms. Allen, good morning.
Good morning, Your Honor.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. When was Ms. Fay convicted, and what were the terms, and why are you seeking a revocation today?
Your Honor, she was sentenced to probation on June the 29th, 2023 for the charge of battery, family violence, where she was required to report to probation, have no further contact with the victim in the case, as well as complete domestic violence classes, as well as pay probation supervision fees. She was scheduled to appear before Judge Mather on August the 30th, 2023, which the defendant failed to appear to that compliance hearing. As of today, we have not received documentation of her completing the domestic violence classes. She's never reported to our office. It is 138 days remaining on her case. Your Honor, she's been in custody since April 28th, 2024.
All right.
Yeah, because it's not enough time to complete the domestic violence classes, probation at this time asks that her balance be revoked.
All right, Mr. Murphy?
Judge, and I've noted everything that probation has announced, and I noticed that the Judge Mather told the probation back on November 9th of this year. So I was hoping to speak with my client briefly and go through some options. I was only appointed by the court late yesterday afternoon.
All right. She's been in custody for 12 days so far, and the state is recommending that we revoke the remainder of the 138 days, give her credit for the 12 days she's been in jail, and have her serve out the rest of the the remainder of the 138 days in jail until her probation, until her sentence is completed. All right. So I'm just trying to see who's hosting right now.
Ms. Strong.
Miss Strong, there she is. Miss Strong, could you place ACDC and Mr. Murphy in a breakout room, please?
Actually, you can call, because I have other defendants here.
Okay,
I think I'm ready to go back to courtroom 2.
Yes.
So I'm
give me that
sorry,
phone.
Taj, I'm trying to rock the 2 different Zoom cases, okay?
404.
Okay.
865.
Okay.
8122.
122. Now, Judge, before we jump off, on this revocation, is it day for day or would 2 for 1 apply?
I will give her credit for the 2 for 1 because she's been in custody at the Fulton County Jail. But presently, based on her complete and blatant disregard of the conditions of the sentence, I'm going to require day for day. So
Okay,
that would be on the remainder less 24 days.
I wanted that clarification. Thank you,
All
Judge.
right.
And
Thank you.
thank you, Judge.
Mhm. All right, Mr. McLean, how are we proceeding?
Your Honor, my client is concerned about several issues here. He really feels the financial pinch and won't be able to perform worth a darn on probation as far as the fines go.
In other words, then, if he wants to plead not guilty, we can further notice this case for trial.
Right.
Unfortunately, Mr. Dumas has to also understand that along with this recommendation by the prosecution, we are also dealing with a very, very difficult record that he has, and that's something he has to live with.
Understood.
So if he doesn't want to accept the offer, would he like to plead not guilty and further notice the case for trial?
I believe so, Your Honor, but here's the point that
Yes, sir?
is salient at this point. That's very important. The thing holding him in jail right now is a $1,000 surety bond on the FTA itself. On the date in question, if we go to the internet and go to Georgia Department of Corrections, we'll find, he says, that he was in prison at the time. So
All right.
in the court, if we can prove that, if I can get to the internet at some point and show that he was in prison on the date that he missed court here, could we please have a signature bond?
I will consider it, but right now, do you plan to file a waiver of arraignment then?
Yes.
All right. On positions 13 and 14, that's going to be a waiver of arraignment. And the case is going to be further notice for trial. And the bench warrant presently has a $1,000 surety bond, subject to verification. Would you like to address that today, or would you like me to reset the case to next Thursday?
Your Honor, if we've got good internet service today, which we will check out to make sure the DCOR site is really pretty good, so I should be able to check it out today.
All right, please let the deputy know to keep Mr. Dumas in the courtroom until you are ready. Okay, next case, please, on courtroom 2.
We can go back to position 18 and 19.
All right. 18, 19, Mr. Middleton. Yes, Mr. Shaw, have we moved forward with the decision? Mr. Calvin Shaw, please unmute. Oh, can you hear me? Mr. Calvin Shaw, can you hear me? All righty. Mr. Shaw, let's see if he can respond to a chat. Mr. Shah? Kalpin Shah? All right, his audio.
My apologies, Your Honor. Mr. Shaw and I were talking
Hello,
on the phone
Judge.
briefly
Oh,
about the
I'm so
recommendation.
I'm so sorry. Okay,
No.
and how are we moving forward?
Your Honor, I believe he's requesting a bond hearing on these charges.
Okay, and would you like me to arraign the case, or would you like to file a waiver of arraignment?
We can file a waiver, or we can go ahead and arraign him, Judge, since we're.
All right, do you waive a reading of the accusation?
We do, Judge.
All right. Mr. Vincent Middleton, with regards to both the cases that I've identified, you are represented by counsel, and it appears that you will be entering a not guilty plea to both these cases and have them scheduled for trial. Please understand that you do have a right to a trial before a judge or a jury with regards to both your cases. At the time of the trial, you are legally presumed innocent of the charges. And if the state carries its burden to prove the charges against you beyond a reasonable doubt, you could be convicted of one or more of these offenses and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. These sentences could be served separately or concurrently. Given this information, how do you plead to battery and criminal trespass in case 21 CR 2132J?
Not guilty.
How do you plead to the offense of simple battery family violence in case 20 CR 377J?
Not guilty.
All right, your cases have been arraigned and they're going to be further notice for trial. If you just give me a moment, Mr. Shah, are you? I'm just pulling up his cases to get the right information. With regards to position 18 for the case from 2021, Mr. Middleton's failed to appear in court, and there was a bond forfeiture issued by Judge Besson on December 22nd, 2022. He's got a probation hold. And looks like his total bond is presently $34,000. And I think it's also based on the probation hold. And he's got also a felony. Oh, no, okay. His felony matter was resolved. Okay, yes, Mr. Shah, 34,000 at the present time.
Yes, Your Honor. So, Mr. Middleton, can you tell the court what you do for work at the moment?
I have a moving company.
You have a what company?
Moving company.
Yes.
Yes.
Middleton, how much do you earn in that regard? When you
I earn like over $1,000 a week. Well, it's been slow during winter and it's just not getting hot, so my business is just starting to pick up before I got recently picked up. So I turned myself in through the probation office.
So can you tell the court why you cannot afford the $34,000 bond on your case at the moment?
Because I have to pay rent, still got my kids I have to take care of. I got graduation coming up for 2 people that's coming out of elementary, and I have a graduation for a girl that's coming out of 8th grade.
You said a daughter that's coming out of eighth grade?
Yes.
Okay. And how many children do you have?
I have 3.
And how old are they?
13 and 2 10-year-olds.
Can you lower your mask?
10-year-olds and 1 13-year-old.
A 10-year-old, a 13-year-old, and what was the third one?
Another 10-year-old.
A 10-year-old. Okay. And you provide for these 3 children?
Yes.
Okay. Does the mother of the children provide for them at all?
Yes.
She does?
Yes.
And do you provide for that mother as well? Do you provide any support?
Rent, the one that's over 2, I paid the rent and I paid my insurance in my car and the light, the water, I paid the bills.
Okay, and with you're aware of the cases, you're aware of the individuals that you have the cases against, right? The battery and the simple battery?
Yes.
Have you had any contact with any of those individuals that are involved in those cases?
No, sir.
Judge, he hasn't had any contact. The cases are quite old. They're almost 3 to 4 years old at this point. He hasn't had any contact with the alleged victims. As you heard, Judge, he's been gainfully employed and legitimately employed, providing for his 3 children who are minors, 13 and 10-year-olds. He's also providing for the mother of those children, paying rent. And for all of those reasons, Judge, if we can lower the bond to a more reasonable amount, to a total of, I'm asking for no more than $4,000 bond. He still has the other charges that he's still in custody for, Judge. So he may still not be able to be released until the public defender's office, whoever's representing him on those charges, resolve those matters or resolve the probation revocation. So that's what I'm asking, Judge.
Okay. Just for the record, on the 2021 case, he's got 1 bench warrant, well, 1 bond forfeiture, but in the other case, he's got 2. So I'd like to hear what Ms. Falk has to add to this.
Well, Your Honor, I always appreciate when the defense points out that the case is 2 to 3 years old when it's only 2 to 3 years old by the actions of the defendant not showing up for court and bench warning multiple times, which this defendant did. Additionally, we've got a aggravated assault case where he was given first offender. He now has a probation violation on that. And in the probation violation, it says the basis for it is new offenses of theft by receiving stolen property and interference with government property in Douglas County on August 11th, 2022. So he's continued to commit new crimes while being on felony probation, including our offenses, which detail that he has attacked 2 different women. One was Kaya Daniels, who he allegedly slapped in her mouth, leaving bruises and swelling on her inner upper right lip. And that happened at the MARTA station and was captured on CCTV. The other offense was an attack against Quinisa Jenkins, where he allegedly refused.
Judge, I'm sorry, Your Honor.
I'm allowed to put the facts on the record, Mr. Shaw, to give basis for why we're asking the bond not be changed.
Your Honor,
Thank you, Ms. Falk. What's the objection, Mr. Shaw?
Your Honor, the objection is that the underlying facts of cases that he's charged in are not relevant to a bond hearing. I understand in general.
Overruled. It is relevant. And the court also notes that these are not facts that have been proven by the state. These are facts that support only probable cause.
I say one more thing.
Thank you, Your Honor.
All right, you may proceed, Ms. Falk.
Thank you, Your Honor. And in the other case, he allegedly took her keys out of her ignition and bit her on her right hand, causing a visible laceration. We did have an opportunity to speak with both of the victims, Ms. Quinisa Jenkins and Ms. Kaya Daniels. Both of them are in agreement with this plea recommendation. And Ms. Daniels has asked that the no contact be kept in effect as well as part of this recommendation. So we are asking that the bond remain as set. I don't see any evidence based on any of the Ayala factors. The defendant has failed to appear multiple times. The defendant has injured 2 individuals and committed new offenses while on felony probation. So he's a likelihood to reoffend. He is also a danger to these individuals in that there was the 2 incidents which are alleged, including a previous aggravated assault. And there was another aggravated assault, which was actually null crossed. So his history is mostly either violence or failure to appear in probation violations. For that reason, we were asking the bonds not be changed. That's all, Your Honor.
All right. Anything
Judge?
else to add, Mr. Shaw? Your client wants to allocute as well.
I'm not going to allow him to allocute without having spoken with me first, Judge.
Okay,
But what I would like to add, Your Honor, is that he has not committed new offenses. He's been accused of committing new offenses. And as we all know, Judge, those are not convictions. Those are what he's innocent of those as of right now. What I was showing to Your Honor was his ties to the community and the three children that he has. And I understand that he may have failed to appear or a bench warrant was issued against him. But the fact still remains, Judge, that he hasn't had any contact with the women involved in the cases that he's accused against. So I'm just asking for a lower bond. That's all, Judge.
okay. Mr. Middleton has indicated that he is a working man, that he is a father, and that he's a parent, and that apparently he works hard to support his family. But he has other obligations as well, with 2 open cases in the State Court of Fulton County, as well as an open case in the Superior Court of Fulton County, which is the probation matter. He has yet gotten himself arrested again in August 11, 2022. So I'm not here to sentence Mr. Middleton. The factors I have to consider is whether he's a threat to the community, whether he's a threat to the victim, whether he has a high likelihood to reoffend, or whether he's likely to come back to court. And he has unfortunately not passed any of these factors. The bond modification is denied. Yes, Mr. Middleton? Your attorney has told you that you should not say anything. You do have a right to remain silent. Anything that you say in open court.
I still want to say, so I've been fighting cases in Douglasville for like 3 months straight. So I've been going to court every day in Douglasville. I've been
Well, understand that. Unfortunately, you also have an obligation in Fulton County, which you have miserably.
I took the probation in Douglas County, and they supposed to ended my probation in Fulton County, and my probation officer never did.
Mr. Middleton, perhaps you're not understanding what I'm saying. You have failed to appear before Judge Besson.
My address is Quanicia Jenkins' address. She threw my court.
You have an obligation to update the court of your new address.
I did, man. We still living together, man.
Yes.
That's what I'm trying to say. Like
that is something you can address with Judge Besson when your case is called for trial. Thank you. Bond modification is denied. Anything else, Mr. Shaw?
No, Your Honor. If I may be excused, and always great to see you.
You too, sir. In the event that your client contacts you and decides that he would like to reconsider the plea, just 1 second, please. Courtroom 2, please mute. Thank you. In the event that he would like to reconsider, you can always reach out to the clerk's office to have the case put back on the SAP calendar.
Understood, Judge. Will do.
All right.
Thank you, Your Honor. Have a great day.
You too. Thank you. Medical, who do we have, please?
All right, next case is 2023.
I'm sorry, what position number is this?
20
Oh, 20.
and 23.
Oh, I see. Okay. By the way, is Mr. Murphy ready to address his probation case? They were on a phone call, so I guess not. All right. Position 20 and 23. Position 20 is case number 23 CR 6577C, State versus Kenneth Pack, accused of criminal trespass. And 21, case is 23 CR 6878C, accused of
I understand, but wait till I get somebody to come in here.
I'm sorry, courtroom 2.
Out of here. No, please, I'm begging you, bro.
All right, thank you. And 21, Mr. Kenneth Pack's case is 23 CR 6878C, accused of criminal trespass and simple battery against a police officer. And position 22, Mr. State versus Kenneth Pack, case is 24 CR 000040C, accused of criminal trespass and violation of certain rules at a bus or rail station. And the fourth case is 24 CR 2251C, State versus Kenneth Pack, accused of criminal trespass willful obstruction of an officer, violation of certain rules at the bus or rail station, and a PI charge. And this is from April 24, 2024. So these are 4 open cases against Mr. Kenneth Pack. And Mr. Pack, you have a right to remain silent. Anything you choose to say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Mr. McLean, has it calmed down in courtroom 2? If you'd like to unmute. Mr. McLean, if you'd like to unmute.
Your Honor, we were just able to unmute.
All right, sir.
It's calmed down a little bit. It was kind of loud in here for a while, but I think I did hear what the court was saying. I believe that Mr. Pack is offering to the court today, based on my discussion with him yesterday afternoon, he'd like to do a non-negotiated plea in that at one point we were looking at, correct me if I'm wrong, please state, but 12 and 60 and 5. So on a 60-day sentence with 5 days credit, 30 minus 5 equals 25. And we believe the offer includes 25 extra jail days. And he was asking me to put forth a non-negotiated plea to ask the court if that could be less, including 0 extra days.
All right. So Ms. Falk, why is the state seeking additional time for Mr. Pack?
Well, 2 things, Your Honor. 1, he has 4 cases with this court. So that's quite a few cases just to give a time served recommendation. 2, the bigger issue is on the case where I did ask for jail time. The allegation is that the defendant fought an officer. He kicked him, pushed him away from a wall, kicked the officer, and then said, "Ha, I got your nuts. You ain't going to be able to have no kids." So yes, attacking an officer is something that for the state is going to warrant more time than a time served recommendation in this case. That, along with his 4 criminal offenses and his history of 24 cycles, we feel warrants at least 60 days.
All right. Ms. Tyson, how many cycles does Mr. Kenneth Pack have?
I have a total of 28 cycles, beginning in 2011, and majority of the cycles actually begin in 2017.
Understood. Thank you. Mr. McLean, given his arrest history, given the fact that he has 4 open cases with this court alone, stemming from October 21st, 2023, then on November 3rd, 2023, then on January 2nd, 2024, and now on April 24th, 2024, Mr. Pack is not entitled to any rescission on his jail time.
Your Honor, since he's in medical and I'm in jail courtroom number 2, if we could hold his case at some point, I'll be able to speak with him on the telephone.
All right, just give me 1 second. ACDC, is Ms. Fay ready to address her probation matter? Are they still talking? Well, then we'll need to reset the case.
Okay, I'll let him know.
All
Okay.
right, thank you. Then we'll take another case with
And
Ms. Vigilante. And Mr. and medical, is there a number he can call to talk to Mr. Pack? Medical? All right, I guess we'll hold off on Mr. Pack and address somebody else.
given the litigation situation, Your Honor, apparently there wouldn't be harm in resetting the case if we had to.
Which one, Mr. Pack?
Mr. Pack, we
All
could
right.
do that a week easily, and that wouldn't change the days.
If that's the defense request, the case is reset to May 16th.
Okay, let's do that. That's easier than trying to arrange this stuff.
Mr. McLean, I'm sorry, Mr. McLean, Sergeant Glanton's gonna bring Mr. Pack down to you.
Okay, Mr. Pack's coming to our courtroom now, Your Honor, so
All right, you let me know if you still want it on May 16th. Thank you.
Excellent.
Medical, who do we have, please?
We have position number 21, Mr. Tyreek Barnes.
Bonds, like BONDS?
BARDS number 4 on the calendar.
Number 4, okay?
Your Honor, the state does have an announcement on Tariq Barnes.
Yes, ma'am?
We were able to discuss the case with the DA's office. So long story short, this all happened during Cybergeddon. So I feel like that should kind of be self-explanatory as what went wrong. But the DA's office had, the defendant had a set number of charges that he was arrested on, then was arrested again on a different set of charges that happened 13 days later. All of the cases got PI numbers up in felony division, but at the same time, because of Cybergeddon, we accused the misdemeanors, not realizing they were part of a larger felony case. So what we are going to do, and we have spoken to the DA's office about this, and I'm sending the transfer order over. We're sending a transfer order to them so they can connect our case with the already existing charges that are upstairs in the DA's office. They actually have our charges under a DA office number right now. It's just we opened a case at the same time accidentally.
Would it not be as appropriate to just null pros these?
No, because there's warrants underpinning these charges. And if we null pros the case, we null pros the warrants, and we're not null prosing the DA's warrants. They want to continue with the charges.
Yeah,
So by null prosing them, we're gutting the warrants. Additionally, he's not actually in jail on any of the charges on this case. He's in jail on a cruelty to children in the first degree, where he's not sitting on a $25,000 surety bond.
Right. Yeah, you see my concern about how it looks on paper with him having more charges than he really does.
Well, y'all can discuss this. In the meantime, Ms. Falk, please submit the transfer to Superior Court order. And could you specify the case numbers to which this misdemeanor case is being transferred?
I will, Your Honor.
Then, and then the clerk's office will note that this misdemeanor case is closed out and no longer pending, as it's now a Superior Court matter.
Yes, Your Honor.
So Judge, without the transfer order, can we reset to the 16th?
Yes.
I will say, yes, please reset to the 16th, but they said they will be able to get this to me by today. So I just need to send it over to them to have them sign it.
All right.
Okay.
Mr. Barnes, with regards to the charges that have been brought to you in state court, these misdemeanor charges, they're now going to be joined and consolidated with an open and pending felony case that you have in the Superior Court of Fulton County. So all your cases are going to go to the Superior Court, and please contact your public defense attorney who's handling your Superior Court cases, your felony cases.
Is there a way I can talk to my lawyer? Because that's not what was explained to me yesterday.
Well, this is information that your lawyer received today as well. So the information your lawyer gave you yesterday was true and accurate yesterday, but we have been given new information from the prosecution, so that's the status today. But your attorney will reach out to speak with you, but I highly recommend that you reach out to the public defense attorney handling your felony cases.
But I'm not understanding exactly what is going on. Like, there's too many transfers in this case. I have no idea.
There's no too many transfers. This is the one transfer from state court to Superior Court.
No, what I'm saying is there's been modifications in this case since I've been incarcerated. They've actually tried to charge me twice for the same misdemeanor charges. So I don't know whether these misdemeanor charges are staying misdemeanors or you guys are trying to upgrade charges.
All right. Those are legitimate questions, and I'm going to let your attorney speak with you. Mr. McLean, please make a note to reach out to Mr. Barnes and explain to him why his case is being transferred to the Superior Court.
Very good.
It's a consolidation. It's not additional charges. All right. Thank you, sir.
We can do 5 and 6. The March is
All right. All right, ACDC, medical, I'll be with you shortly. Is this Ms. Fay?
Yes, Judge.
All right. Mr. Murphy, how are we proceeding on Ms. Fay?
So my man, McLean, he gonna come up here, he gonna talk.
I'm sorry, courtroom 2, please mute. Thank you.
Ask him everything. Like,
And medical, please mute.
Just
Ms. Strong, please mute medical. Thank you. Please mute, thank you very much. Thank you. All right, Mr. Murphy, how are you proceeding with Ms. Fay?
Judge, we would just have oral argument on this revocation hearing.
All right, so the state's recommendation was to give her credit for the time served. She's got 138 days. The court would give a credit of 24 days, which gives her a remainder of 114 days left to serve at the jail. Yes, sir.
Judge, our position is that my client was homeless and remained homeless. She was not picked up on the new charge. The police were, she requested the police to be able to retrieve some items. They ran her ID to confirm who she was, and then she was taken into custody. Judge, if she was revoked and she served 94 days in custody at the time she took the plea. And if we were to be revoked for another 138, theoretically, she would have been at 232. And she would have to go day for day.
Was she given credit for the time served at the time she was sentenced?
Yes, she was
So
credited.
let's not double down on that.
Okay, well, Judge, I just think that she would be serving more than 180 days. I just feel, given that there was a lack of resources, she had nowhere to go. She said she did go to 132 Mitchell Street to try to report, and they did not have the right probation officer. And again, she never had a definable mailing address or any resources to really get this thing done, and probably not trying to work behind. I'm not trying to stand over somebody's shoulders, but it looks like that she was set up for failure, Judge. And I'd simply ask that the court just revoke her for the time and just close out the case. I feel that that's where we are. I don't think this was something that was blatant or belligerently a lack of compliance. I think it was just a lack of resources, and that's where it took us. But again, she's not here on any new charges, and she certainly did enough time at the time of the sentence. She had 94 days in custody.
Understood.
And Your Honor, it is 138, revoke 138. I think I heard him say 180 days.
No,
But is it-
no, I understand what he meant. He was also using the terms of the sentence.
Okay.
So I am looking at the disposition. She did plead guilty to battery, family violence, and she was sentenced to 12 months. She was given credit for 94 days. So the time that she served at the jail prior to the plea, she was given credit to serve that time. And she had 188 days left to serve, during which time she was required to do a DVIP. She was ably represented by competent counsel, and there was a representation that she would complete her requirements. I am trying to see where she was required to do a DVIP. Miss Allen, I don't see that in the disposition sheet. Am I missing it?
And this is for Ms. Fay. Yes, it's on the general conditions of probation. It would be I'm assuming the second sheet on your end.
Allen,
Second, third sheet.
okay.
My
She was required to do a domestic violence, and at the time that she conferred with counsel, there was a representation that she would be able to do that. But nonetheless, she just never reported, and then she never reported to Judge Mather's courtroom. So it's not a question of resources. It was just a question of not reporting to court.
Well, Judge, she did take the plea at the jail court. and
Understood? But
Perhaps at the
that was
courthouse.
explained to her as well.
Yes,
So
Judge.
anyways, I'm not arguing with you, Mr. Murphy. I'm just saying that I understand your position, but I also understand from the state's position is that she was required to complete, at least at a bare minimum, to report and then explain to the probation officer why she's having difficulty completing her domestic violence classes for the criminal act that to which she pled guilty. The sentence is with regards to 138 days, those are revoked. She'll be given credit for 24 days, which leaves the remainder of 114 days left to serve. I will allow her for 2-for-1, so she has 57 more days to serve at the jail, after which the sentence will be completed.
Thank you, Judge, and I appreciate the grace of the court, given that when you clarified it initially, you said you might be inclined to make us do day for day. So I appreciate that the court reconsidered it, and thank you, Your Honor.
All right, thank you. That concludes this case. Moving back to medical, ACDC, I'll be back with you. Medical, what do we have, please?
Courtroom two, we can do 5 and 6 in courtroom 2.
5 and 6 in courtroom 2. Okay. This is State versus Marcus Bell, Mr. Marcus Bell Senior. First position 5 is 20 CR 3475Y, hindering a person from making an emergency phone call and battery family violence from May 23rd, 2020. Mr. Bell has a bench warrant from April 3rd, 2024, 24 FTA 510. Mr. Bell, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Yes, Ms. Vigiletti?
Yes, Judge. A few minutes ago, I sent yourself and Ms. Fox a proof of incarceration for Mr. Bell from April 1st until May 1st. He was incarcerated in Gwinnett County Jail. And so that should be in your email. Please let me know if it's not. And so this morning, Mr. Bell would like to plead not guilty, and we're requesting a set aside of the bench warrant on the failure to appear.
Let me see. Ms. Falk or the prosecutor, if anybody would like to confirm?
Looking now, Your Honor.
I don't have it.
I'm sorry.
That's okay.
I can.
Yeah, yes, Ms. Vigiletti, I have it.
Okay.
It looks like, Your Honor, it does encompass the time periods listed. Let me just look one more place.
Arrest date was April 1st, 2024. Release date was May 1st, 2024 from the Gwinnett County Sheriff's Office. So it appears that he didn't show up in court because he
Was in jail in Gwinnett.
Okay. And how would the state like to proceed?
Based on this information, Your Honor, the state is fine with lifting an order to lift the bench warrant. I mean, this is proof that he was incarcerated during the period of time that he would have had to appear in jail, appear at court.
I'd like to clarify one thing first, though. Just because Mr. Bell was incarcerated in the Fulton County Jail does not relieve him of his obligation of failure to appear in court on April 3rd, 2024. There was the burden is on him to reach out even from the Gwinnett County Jail through either himself or his family or someone to let the Fulton County Court know that he is incarcerated and unable to appear. That there is a burden there. This is not simply the court simply saying, oh, okay, bench warrant canceled because he's in jail somewhere else. I do not want to convey that message. That's not the correct message. Mr. Bell, even if you're incarcerated somewhere else, it's your responsibility to get on the phone, even at the Gwinnett County Sheriff's Office. And I know they always have those phones available. So don't give me any excuses. It's your responsibility to contact either family, friends, or the court, or your public defense attorney or your attorney to let them know you won't be able to make it to your April 3rd court date. All right? Now, presently, I believe that he is, I don't know if his other bond has been forfeited, so I'll need to look at that. That's position 5. Ms. Vigiletti, are you, while I'm pulling up the case, do you know if your client's bond has been forfeited?
I'm not confident. I believe the FTA has its own $2,000 surety bond, but I'm not confident if that previous bond, if they've started the forfeiture process or not.
All right.
I don't believe so, Your Honor.
So it was a bench warrant issued by Judge Morrow on April 3rd for failure to appear in court on that day.
Correct. But there hasn't been a forfeiture.
So we're going to go ahead and set aside the bench warrant and reinstate his original bond. And I want to see what the original bond was so that he has no mistake. I don't see a bond order So let me go ahead and set one. Ms. Vigiletti, you can send in the proposed order. First of all, on 24 FTA, we're going to set aside and dismiss it on the grounds that he was incarcerated in Gwinnett County Sheriff's Office. And you might want to either attach the document that you provided or reference the case number. And then on position 5, on the hindering a person from making an emergency phone call is going to be $1,000, and the battery fine family violence is going to be $2,000. It's going to be a signature bond through pretrial services. Level 1. No contact with Brittany Owens, no alcohol, no illegal drugs, and no firearms.
Okay, thank you, Your Honor. I will get that
And
done.
A must maintain a current mailing address at all times.
Yes, and I did verify with Mr. Bell, the address that the court has is the correct address.
All right, I appreciate your help. Thank you.
Thank you, Judge.
Please explain to him he's required to report to pretrial once a month. Thank you. All right, yes, medical, was that position? I can't remember, sorry.
This is positions 2 and 3, Mr. Ronald Anderson.
All right, thank you. This is State versus Ronald Anderson, case 24 CR 2012Y, accused of simple battery family violence, and 24 CR 2013Y, accused of battery family violence. The first one is simple battery. Second one is battery family violence. The former case is from July 29th, 2023. The latter is from April 17th, 2024. Mr. Anderson, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Ms. Vigiletti is your counsel. Can you see Ms. Vigiletti on the screen?
Yes, Your Honor.
All right, Ms. Vigiletti, you've got 2 ifs in your announcement: possible and non-negotiated. So
Yes.
what's the definitive announcement?
Well, if it is at all possible, Your Honor, to speak with Mr. Anderson briefly. I actually just had a couple of calls this morning on his behalf, and so I do need to give him some updated information.
All right, who represents the gentleman at ACDC?
I do as well, Your Honor. I'm sorry about that.
We can go to position number 24.
I was gonna say, we do have 2 left over here.
Either one of them represented by Mr. McLean?
I have no idea.
I also represent Ms. Tittle, who I see is also waiting.
Ms. Tittle, okay, who represents Mr. Carlton on the probation? You too? Okay,
Wait, probation.
yes, Ms. Tittle is on probation.
What's the first name of Mr. Carter?
Juan, is it Juan? Juan,
Memory of a Juan Carter. Let me check for you.
okay, thank you.
All right, Ms. Vigiletti, could you also reach out to medical? How are you having the attorney speak to the defendants?
I can join the Zoom call if we could be placed into a breakout room. I have my phone right here.
All right, go ahead and join the Zoom session, and then we'll put you in a breakout with medical.
All right, come on. I don't see why that. Speed up.
This is position 20 and 23.
All right, Mr. McLean, do you represent that gentleman at ACDC, Mr. Juan Carter?
No, Your Honor, not that I know of, not that I've seen on the list.
All right. Who do you have right now next to you? Positions 20 and 23, 22 and, no, so who do you have?
This is Kenneth Pack, who used to be on the cell phone.
Yes, so what are we doing?
We're doing a plea, it's a negotiated plea, Your Honor.
All right. Mr. Pack has already been advised of his case numbers and his cases and of his rights. What is the global offer from Ms. Falk?
Yes, Your Honor. The state's global recommendation is as follows. On case number 20, the criminal trespass, 12 months, serve 8 days, credit for time served 4 days. That's going to be from October 21st to October 24th of 2023. Balance suspended, stay away from all MARTA. Position 21, criminal trespass, 12 months concurrent with count 2. On the simple battery against police officer, 12 months served 60 days, credit for time served 5 days. from November 3rd to November 5th of 2023. Balance probated, stay away from all MARTA, 12 weeks anger management. On position 22, the criminal trespass, 12 months to serve 6 days, credit for time served 3 days. That's going to be from January 2nd to January 4th of 2024. Balance probated, stay away from all MARTA. And on count 2, certain acts prohibited, 12 months probation concurrent with count 1. Position 23, the criminal trespass, count 1, 12 months served 30 days, credit for time served 15 days from April 24th, 2024 to today. Balance probated, stay away from all MARTA. On the willful obstruction of an officer, count 2, 12 months concurrent to count 1 with a $300 fine. On count 3, certain acts on a bus or rail prohibited, 12 months probation concurrent with count 1. And on count 4, the PI charge, 12 months concurrent with count 1. That's all for the state. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
Yes, for those purposes, we do so stipulate. And let me mention one thing that I am at fault for leaving out. I had not written down the $300 fine that is associated with the allegation of the obstruction. So
It's part of the statutory recommendation.
I had failed to convey that part of the offer. My apologies. You understand there's a $300 fine with that.
When going to the anger management class.
Well, the anger management classes will cost you about $200 or $300, but there's the separate $300 fine.
Oh, please mute your screen, Mr. McLean, unless you. Thank
Okay.
you. Medical, did you get the message to, I'm sorry, Miss Strong, if you could place Olivia and medical in a breakout, please?
Yes, ma'am.
Thank you. Okay, there we go. Mr. McLean, are we ready to proceed?
Excuse me, Judge, while they're holding, and Ms. McLeod, on position number 22,
Yes.
it's 12 months served, 6 days, credit for time served, 3 days. Count B is concurrent with A, stay away from all MARTA. Is that suspended since there's no conditions?
I would, that's what I was going to go through, but I'm still waiting on Mr. McLean to let me know how they feel about the $300 fine. So let's hold on that.
Okay, thank you.
Your Honor, if we could convert the $300 fine to community service hours, that would help him financially since he's going to have to find and pay for the 12 hours of anger management anyways of limited income.
What exactly is that income? How is he going to afford? I have a residential challenge, I believe.
Yes, it's a social security check, Your Honor, so it is limited. He's got to spend almost all of it on housing as best he can and food. So he's going to be strapped financially.
And he will have to stay away from MARTA, so he won't have transportation, and he'll need to do these anger management classes. Could you explain to me how your client plans to do that?
Well,
based on the information I have, I don't know how he's going to accomplish that.
It's going to be extremely difficult. We did discuss that, Your Honor.
Especially after he serves the additional time at the jail.
Correct. He's intending to get it done, but he does wish to offer it as a negotiated plea now.
Your Honor, on position 22, we're agreeable to balance suspended. On position 23, on count 2, what we can do is time served 30 days, credit for time served 15 days to run concurrent with count 1 on position 23. That will remove the fine.
All right, so on criminal trespass, we're still keeping the stay away, correct? And on count 2 is basically to serve how many days?
30 days to serve 15 days credit for time served. So it's a time served.
Balance suspended. Okay.
Yes. Well, I mean, count on 23, the balance is probated.
On count 23, I'm sorry.
Sorry, on case number 23, position 23. The balance is going to be probated, not suspended.
Not, okay. Balance probated and remove the fine?
Correct.
Is that allowed under the statute? If you're putting him on probation?
To remove the fine, well, we're giving him time served is to count 2. So really, he's only traveling on counts 1, 3, and 4. Because time would be just time served on count 2. Either that or we can null cross count 2. I'm fine either way.
Let's go with null pros. It makes it less difficult.
Okay.
If the state's offering a null pros.
Any
Any objection to a null pros, Mr. McLean?
Certainly not, Your Honor.
All right, so count 2 on position 23 is going to be null pros.
But and I will point out for the court, the stay away from all MARTA, the defendant is currently on, when I read the reports, on a lifetime ban from MARTA. So whether or not we give him a stay away from MARTA, he's not allowed back on MARTA.
That's entirely up to Mr. Pack. He can either stay away from MARTA or go on MARTA and then come back straight to jail. So entirely up to him. Mr. Pack, do you understand that you have a lifetime ban from all MARTA facilities? No trains, no buses. You cannot go back on the stations and you cannot be using their bathrooms or their parking lots.
Yes, Your Honor.
And if you return to any of the MARTA facilities, you'll be back in jail to face one of us.
Yes, Your Honor.
And how do you feel about that? Is it doable?
I'm just trying to see if I could afford the anger management and the spot to stay, or if I could just do 12 months probation and avoid having to pay for anger management.
You will have to pay for it. That means you'll need to get a job and use your check and pay these classes. Are they doable?
With Social Security, I would have a hard time unless I could still be homeless and pay this debt off.
So then this plea cannot go forward. Mr. Pack is unable to carry out the requirements of the plea.
Well, Your Honor, we could refer him to Tin Park Place if he's indigent. Tin Park Place is Grady Mental Health and could probably provide some kind of 12 hours of anger management equivalent, perhaps for free.
All right, then that's an option that he should seriously consider. All right, Mr. McLean, do you stipulate to the factual basis, venue, and ID for all these 4 cases?
We do.
And does your client accept these terms?
He does.
All right, Mr. Pack, I'm going to move forward with this plea if you have an alternative to obtain a waiver of your fees for your anger management classes from Tin Park Place. But please keep this in mind. I don't tend to forget cases where individuals have this kind of situations, 4 straight open cases in a short time period. And if you don't comply with probation and they arrest you on a probation warrant, I will have you serve out the rest of the years in the jail. Do you understand? So you tell me truthfully right now, will you report to probation every month?
Yes, I will.
All right, that's all I'm asking you. If you're having problems with your anger management classes, that's a problem, but you still must report every month and you must avoid getting arrested again.
All right.
No, you don't sound too convincing on that one.
Although I don't have a spot to stay, I can't ride barter. Those are the 2 main issues: spot to stay and transportation.
They're going to be difficult, but I've written down, Your Honor, about asking to get a Grady card so that he can use the free services of Grady. Sounds like he's going to be eligible.
Okay, I'm going to trust you, Mr. McLean. Let's put it that way. Mr. Pack, have you consumed any medicine or alcohol?
No, Your Honor.
And have you understood what's going on in all your 4 cases?
Yes, about criminal trespass, disorderly conduct, or simple assault against the officer, some things where they want me to do probation, pay a fine, stay off MARTA. Can I accomplish it? If I had a trustworthy family's house, which I do not, that I could stay at, I really could.
So you've understood the cases,
Yes,
and you understand that you keep getting arrested in a very short time period, 4 open cases.
yes,
And you understand that they all stem from being at MARTA.
yeah,
So MARTA is a very dangerous place for you.
yeah, it's dangerous.
All right. If you decide to plead guilty to these charges, you would have to give up your constitutional right to challenge them in a court of law. You will not get a chance to go back to court and have a trial. You will not get a chance to have your attorney help you in a trial. Well, why don't we address this case next week when he'll pay attention, Mr. McLean?
Oh, I'm paying attention, Your Honor.
Not you, him.
He's watching this now.
Yeah, I think he's just watching me tape his instructions together. We've got some written instructions here, so. Yeah,
So
this will help us.
why don't we take this next week? Because I'm just getting a little frustrated with this man's inattention. So we'll take it next week,
Very good.
May 16th, and maybe give him all the instructions beforehand so that he will learn to pay attention in court next time.
We'll have her done.
Thank you. These cases are reset to May 16th.
Hang on to this.
My case is reset.
Yeah, I'll see you in a week.
Thank you. ACDC, I'm sorry. Ms. Vigiletti, is she ready to address medical?
No,
For Mr. Anderson?
he's not ready yet.
Okay.
Can we go to the add-on calendar? You can address my phone, sorry.
Folks, y'all need to let me know I've got ACDC ready and I've got medical on Zoom. So
I do have, Your Honor, an announcement on Mr. Guest, the add-on positions.
tell me what's the announcement, then I'll move on to ACDC.
Not guilty, bond is moved.
Okay. Positions 1, 2, 3, 4.
Correct.
All are going to be further notice for trial.
I'll sign a waiver on his behalf. I have permission.
All right. Thank you, sir.
Thanks.
ACDC, who do we have in the seat?
We have, are you ready for Santano?
Yes.
So we have on the add-on calendar probation. We have position 1 and 2, Mr. Carlton. First name Juan.
Judge, I apologize. I don't believe I realized that there was an add-on probation as well. I saw the add-on main calendar. I don't have any information about this person.
Okay, what about Tittle?
Hang on, folks. All right. Carlton Hall is position 5 and 6 on the updated probation revocation calendar.
Okay, Juan
Is that-
Carlton.
Yeah. No, the only name we have is Carlton Hall. We don't have a Juan Carlton's position 1 and 2 on
Okay,
the calendar.
okay, so there's a new calendar for probation.
So is
on
that,
Carlton Hall.
just a second, Mr. McLean, just a second. Ms. Vigiletti, is that your client, Juan Carlton?
Judge, I don't believe he's been assigned because I did not know about him.
Okay. Who would like to speak with him? Would it be you or Mr. McLean?
I believe I represent the person at medical, the other person at ACDC, and most of the guys here. So if it's possible, do you have a minute to talk to Juan Carlton?
I sure do.
Okay,
Okay.
Mr. McLean will take him.
All right, appreciate it.
Okay.
Thank you. All right,
Call 40
Juan Carlton is going to speak with Mr. Michael McLean. Who else do you have left at ACDC,
I
Sergeant?
have, on the SAP calendar,
No. Who else? Okay, go ahead.
I have Santano Brian, number 27.
Okay.
And then I have on the probation calendar, positions 9 and 10, Tittle.
Okay. And are they both Ms. Vigiletti's clients? Ms. Vigiletti, can you confirm?
I apologize, Judge. I was just updating Mr. McLean on Mr. Carlton. I have an Ashley Tittle at ACDC, and I also have a gentleman at ACDC.
Okay. Let's start with Ashley Tittle, please.
Okay,
Call you. And Mr. McLean call 404-865-8122.
yes, I will ask him to do so.
Thank
Thank
you.
you. All right. This is State versus Ashley Tittle, case 23 CR 2815J, accused of theft by deception from April 27, 2023. Ms. Tittle has a probation revocation case 24 PB 758. Ms. Tittle, you have the right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Olivia Vigiletti. Ms. Allen is our probation officer, and she's already been sworn. Ms. Allen, when was Ms. Tittle convicted, and why are we seeking a revocation?
Your Honor, she was sentenced to probation on May 16, 2023 for the charge of theft by deception. She was required to complete a shoplifting course. She's never reported to our office. She's failed to provide documentation of completing the shoplifting course. Your Honor, we received information this morning showing that the defendant was incarcerated with the Georgia Department of Corrections from August the 30th, 2023 until May 1st, 2024. Your Honor, as far as this case is 240 days, but in light of the new information, probation recommends her case to be time served.
Ms. Vigiletti, does your client accept this recommendation?
Yes, I believe so, Judge. I also sent you the information I was able to find. Ms. Tittle has been in continuous custody since she took this plea from May 16th last year. She moved to Henry County and then I believe Spalding County, and as Ms. Allen said, to GDC custody.
All right. Is she going to be sent back to the DOC custody?
I believe this concludes her custody. She served her sentence at GDC.
All right. Ms. Tittle, this case is going to be marked as a probation violation, and your time that you have served to date is going to be commuted. This sentence is going to be commuted to time served. So your obligations for this case are over. Thank you. ACDC, the next case with Mr.
Santano.
This is State versus Brian Centeno, case 24 CR 9268, accused of criminal trespass at Georgia State University on February 26, 2024. Mr. Centeno, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. Your attorney is Ms. Vigiletti. How are we proceeding, Ms. Vigiletti, on position 27? Negotiator, please.
I realized this morning I said negotiated plea. I don't know if this is enough of a request to make it non-negotiated, but Mr. Santano was wondering if it's possible for his probation to go non-reporting upon completion of the community service. But aside from that request, I believe he's prepared to enter the plea this morning.
What is his criminal history record? Ms. Tyson? Ms. Falk, do you have his criminal history record?
I do, Your Honor.
Sorry, Ms. Tyson.
It's okay. Your Honor, he has 33 arrest cycles that begin in 2016.
Begin in 2016?
Yes, Your Honor.
All right, thank you. Request denied. Ms. Vigiletti?
Okay, in that case, Your Honor, I believe I need to speak with Mr. Santano again.
All right,
I will join Zoom once again.
All right, go ahead. And then ACDC, was that your only case left?
Hey.
All right, Ms. Vigiletti?
I have the one left for Mr. McLean. That's all I
That's fine.
have.
We're gonna put you in a breakout room with Miss Olivia. So wait for the message on the screen to go into a breakout. And Miss Strong, if you could place Zoom panel Olivia and Fulton ACDC in a breakout, please, that would be great. Thank you. Medical, who do we have, please?
This is Mr. Anderson, positions 2 and 3.
Oh, I believe that was Ms. Vigiletti's client as well. All right, please hold. Let's go ahead and mute courtroom 2 while both the PDs are in conversation. Do I have any conflict attorneys? All right. We have a bench warrant matter as well, a DV bench warrant that's scheduled for 11 a.m. Is there a Kevin Cook on Zoom? All right, maybe he'll appear at 11. All right, folks, we'll be in a brief recess until Mr. McLean and Ms. Vigiletti appear. Thank you. Oh. Okay. Ms. Vigiletti, are we ready to proceed? Are we ready to proceed?
Yes, Your Honor. Mr. Santano, at ACDC, position 27, would like to enter the plea as negotiated this morning.
All right. Mr. Santano, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
Thank you. Mr. Brian Santano is accused of criminal trespass at Georgia State University property. And what is the recommendation from the state?
Your Honor, the state's recommendation is 12 months served with 4 days to serve, credit for time served 2 days from February 26th to February 28th of 2024. Balance probated, stay away from all GSU property and 40 hours of community service. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
Stipulated.
Mr. Santano, have you consumed any medicine or alcohol?
No, I have not, Your Honor.
Have you understood the proceedings so far?
Yes, I have, Your Honor.
And are you satisfied with your attorney?
Yes, I am satisfied with my attorney, Your Honor.
If you decide to plead guilty to this charge, you would have to give up your right to go back to court and have a trial in front of a judge or a jury. You will not have your attorney help you to confront your accuser, challenge the evidence brought against you, present any of your arguments and defenses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I'm prepared to give up these rights, Your Honor.
You understand that you'll be on probation for the next 12 months where you have to report once a month. You have to stay away from all Georgia State University property, which is pretty big. And you will have to do 40 hours of voluntary community service. Are you prepared to do that?
Yes, I am, Your Honor.
You understand that if you don't comply, you could be arrested again and serve out the rest of the year in the jail.
Yes, Your Honor.
Right? Are you still willing to proceed with this plea?
Yes, I am, Your Honor.
How do you plead to 1 count of criminal trespass?
Plead guilty.
Your sentence is 12 months to serve 4 days, credit for time served 2 days. The remainder of the time will be on probation. You will report to the probation office on Monday. Today is Thursday. You will report next Monday, which is going to be May 13th, and you will report before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. If you fail to report, a probation warrant will be issued for your arrest. While you're on probation, you must complete 40 hours of voluntary community service. You must begin with at least a minimum of 5 hours of community service per month and finish at least 5 hours of service every month thereafter. You can do the community service at any nonprofit agency that's not a church and not a school. And once you complete your probation, your community service, you will continue to report to probation once a month until the remainder of the 12 months are completed. Understood?
Yes, Your Honor.
And as I said, to stay away from all property belonging to Georgia State University, which pretty much knocks you out from most of the property in downtown Atlanta.
All right, Your Honor.
Thank you.
Thank you.
You ready for,
Position 2 and 3, Anderson.
Judge, if we can address this briefly. If it's possible to have a reset on Mr. Anderson, address his case next week, either Tuesday or Thursday.
Reason?
Yes, Judge.
The reason, please?
So this case involves Mr. Anderson's long-term partner, Andrea Jones. She was also arrested at this time. She's been in custody. I have been having a difficult time getting a hold of her. I am told that they still want contact and that she will definitely still want him to live in the home with her. But because she was in custody, I've not been able to reach her. But I spoke with Mr. Anderson. We have a new strategy for how I might be able to reach her if she's been released. And so I'd just like an opportunity to speak with her and just verify before we make our argument that Ms. Jones does want custody, because the plea offer does involve Mr. Anderson moving out of their home.
All right, the case is reset to May 16th at 9 a.m.
And this was his positions 2 and 3?
Yes, 2 and 3. Ronald Anderson.
Thank you, Judge.
All right.
Can we go to the add-on calendar? We're gonna do position number 5. That's what Tiffany Hendricks. Come on, Hendricks.
Is Tiffany Hendricks the person in courtroom 2? Okay.
Yes.
I know. So this is State versus Tiffany Hendricks, position number 5 on the add-on calendar, case number 24 CR 21498. How would Tiffany Hendricks like to be addressed pronoun-wise?
Mr. Hendricks is male, he him.
Okay. Mr. Hendricks, you've been accused of a misdemeanor battery charge of a particular nature. We're going to waive sounding on the charge. And this is from April 22nd, 2024. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Olivia Vigiletti. How would you like to proceed, Ms. Vigiletti?
Mr. Hendricks would like to enter a not guilty plea, Your Honor. I'm happy to file a waiver of his arraignment. We also have a bond request.
All right, you may proceed with your bond request.
As you can see, Brent from Positive Impact Health Centers is here this morning. We were connected to Positive Impact Health Centers through PAD. Mr. Hendricks is a part of the PAD program. He has been, PAD has been working to get him treatment for addiction. And so Mr. Hendricks has agreed to enter into the Positive Impact Health Centers program. Brent is happy to speak more about what that looks like. We've also gotten him into a sober living program that will run simultaneous. So I spoke with Tyler at Freedom Arch, which is a sober living program this morning, who confirmed that they do have a bed waiting for him. So, in light of these great programs and the work PAD is doing with Mr. Hendricks, of course, I believe his time would be better served in these programs rather than in custody as he fights these charges.
With regard to sober living, you said he has a bed available?
Yes, the program is called Freedom Arch. I spoke with them on the phone this morning to verify, and Brett also coordinates with Tyler at Freedom Arch as well.
And how do they check in and check out with Freedom Arch?
Are you aware, Brent, of exactly?
Well, I'll ask Mr. Brent if that's okay. All right. Sir, if you could tell me your full name, please.
Hi, my name is Brent Jones.
Brent Jones, all right. And Mr. Jones, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I swear.
All right, and what's your position with Positive Impact Health or with Freedom Arch?
I am the day treatment programs manager at Positive Impact Health Centers, as well as a SAMHSA grant program director.
And overall, what is the mission of this Positive Impact Health Center?
The overall mission of our agency is to reduce the viral load of HIV in the community. And we do that by offering many preventative services as well as HIV care. And we consider addiction and the treatment of addiction preventative from stopping the spread of HIV.
All right. And what would you like to tell me specifically about Tiffany Hendricks without referencing or alluding to the nature of his charge at the present time?
I have not had the opportunity to meet Mr. Hendricks. I've only spoken to Olivia about the program that we have to offer. Our program I can speak to, but I cannot speak to any details about Tiffany because I've not had the opportunity to do an intake or assessment.
Judge, I'm sorry, if I could add, Darcy is also here who has a long-standing relationship with Mr. Hendricks as a PAD representative.
All right. Whoever would like to tell me what would happen if I release Mr. Hendricks back out of the jail and into the community? What's the next step?
I can speak to that part. If you were to release Mr. Hendricks, we would, from the information that I've been provided by PAD, we would admit him into our intensive outpatient program, which is a SAMHSA ASAM level 2.1 recovery program that meets Monday through Friday in Decatur, 1 o'clock to 4:45. Mr. Hendricks would be in treatment here for 12 weeks under the intensive. He would also be assigned an individual therapist as well as receive a comprehensive nursing assessment to identify any other mental health needs and meet with a psychiatrist. Mr. Hendricks would be enrolled in our SAMHSA growth grant, which is a grant that provides sober living assistance and as well as other benefits to people who are engaged in our program. That's how we would fund his sober living expenses with Freedom Arch. Freedom Arch is one of our sober living partners. We would also provide transportation to and from Freedom Arch daily for his participation. We would encourage Mr. Hendricks to seek employment, and if he is in need of career counseling, we have a certified career rehabilitation counselor on staff that would meet with him to identify opportunities for employment. Those opportunities would be afforded to him at no cost.
All right. And how do you monitor his attendance and his commitment to the program? Well, let's start with attendance.
We monitor attendance. We expect that's one of the so let me back up. Number one, the number one commitment from Mr. Hendricks is going to be abstinence to drugs and alcohol. We would be monitoring him with random urine drug screens. We do that randomly, but it occurs usually once or twice a month. If you so ordered more, we could increase that random drug screening. Attendance, I monitor that personally every single day, and his attendance is linked to his continuation in the growth grant. So it's tied to the financial payment to sober living. If he doesn't show up, then he becomes responsible for his sober living fees, which at Freedom Arch are $300 per week.
All right. Ms. Falk, I don't have any other additional questions for purposes of bond. Did you have any questions? Sorry, Mr. Jones, this is Shelley Falk. She's the Assistant Solicitor General, who is the prosecutor.
Pleasure to meet you.
I actually have a question for Mr. Jarrett, the PAD Care Navigator. If you could unmute yourself so I could ask you my questions.
I'm here.
Okay, so my understanding is Mr. Hendricks was enrolled in PAD, is that correct?
Yes.
Okay. And how has he been doing in the PAD program?
There is a measure for participation in our program. I would say that I am consistently hearing from Tiffany when they are in a when he is in a recovery program. And so I do think that when he is seeking recovery, he is an extremely alert and on topic, on his purpose of continuing and to make progress, to get, to attain housing, to obtain documents. And so I do believe that a program like this intensive outpatient program is exactly what will help continue to keep him enrolled and in contact with the PAD program.
And how long have you been monitoring Mr. Hendricks through PAD?
I have been with Mr. Hendricks as a care navigator for, I would say, 9 months now.
Okay. All right, that's all the questions I have. Thank you.
All right. Ms. Vigiletti, thank you, Mr. Jones. Ms. Vigiletti, what's your bond argument? He's got $1,000 surety bond at the present time.
Yes, Judge. So we are requesting a signature bond today so that he can be released to these programs. I'm happy to draft an order that specifies he be released specifically to these programs, comply with these programs, or any other terms that you would like to impose as conditions of his bond this morning. I actually spent 6 years in addiction treatment myself before I was an attorney, and would just like to remind the court that addiction is a chronic disease. And so this is something Mr. Hendricks asked me for. This is not something I suggested to him. It's not actually related to the charge, which he will be fighting. And so I do think this will be a great opportunity for him to spend this pretrial time getting healthy.
Thank you. Ms. Falk, anything else to add?
Yes, Your Honor. I will state that the defendant has 78 cycles. That includes a PI from 2001, PI convictions from 2001, 2006, burglary convictions from 2015, 2016, 2020, and he was arrested while he was in the care of PAD in January 2024 for a burglary first degree, which he is currently out on bond for. He also has probation violations. They are quite extensive, but just to recap the last 5 years, 2 in 2018, 1 in 2019, 1 in 2024. And as PD Vigiletti pointed out, this is in fact not related to this offense where he did touch Kathleen Flood inappropriately, a woman who he does not know and who did not know him. And so at this point, Your Honor, I have to look not only at the necessity of treatment for this defendant, but the state also has to take into consideration the danger he presents to others. And at this point, with 78 cycles, some of them of the same type of nature as this, and the fact that this was an offensive touching of a woman he did not know, the state believes a $1,000 surety bond for a 78 cycle recidivist is reasonable.
Okay. I'm going to grant a $5,000 signature bond through pretrial services. It's going to be a level 1, and it's going to be telephonic reporting. Mr. Jones or Mr. Jarrett, it's going to be up to both of your agencies to coordinate how you would like to maintain a monthly contact with pretrial services to make sure that Mr. Hendricks is compliant with the program and that he's not getting arrested and that he has regular attendance and that he's passing his random screens. He'll be subject to a weekly random screen for illegal drugs and alcohol. He's to abstain from all these substances. He's to stay away, have no contact, with the alleged victim in this case. And if you give me a moment. This is to have no contact with Kathleen, with a K, Kathleen Flood, and to stay away from the location at 860 Peachtree Street. Would that affect any of the agencies where he needs to report? No?
No, Your Honor.
860 Peachtree Street. Thank you.
We are downtown Decatur.
Oh, that's right. You did mention that. All right. So weekly screens for alcohol and illegal drugs. He'll need to make sure that he has regular attendance with the program, that he continues to stay at the Freedom Arch location, and that he's compliant with all rules, whether he's been governed by PAD or whether he's governed by the Positive Impact Health Centers, and he cannot get arrested again. Unfortunately, if he violates any of these conditions, he will be back in jail, and this time facing a $5,000 surety bond. Mr. Hendricks,
Yes,
this
ma'am.
is one of those rare miracles where there is not one shining light, but two shining lights that are bestowed upon you, where you have the benefit of an amazing, spectacular program to help you get back on your feet and be a valuable citizen to the community. And this is being done totally at no cost to you, but through grant money that could also be used for other people who are in dire need. And if you don't recognize that this amazing gift that's been bestowed upon you, then all I can say is shame on you. Because if you don't bootstrap yourself and take advantage of these gifts that's been presented to you today, you would be an amazing embarrassment to others in need. So help your fellow man and help yourself by being compliant with this program and getting back on your feet, because there are people out there who are willing to help you. And if you turn your back on them, so will others. Thank you.
Thank you, Your
Thank
Honor.
you, Judge.
Ms. Vigiletti, please submit your, I'm sorry, is it Dr. Jones or Mr. Jones? Thank you so much for your input. Mr. Jarrett, thank you very much.
Thank you, Judge.
Probation 3 and 4, Smith.
Three and four. I'm sorry, which calendar is this?
Probation.
Oh, probation, sorry, okay. Okay, three. Ms. Vigiletti, who do you have seated next to you?
Oh, yes, Judge. So next to me is, I'm sorry, I was prepared for our medical here. Next to me is Alfred Broughton, position 7 and 8 on the SAP calendar.
Is that who you're referencing, Deputy?
The deputy is, this is Mr. Sebastian Smith here at medical. He is on the probation calendar. I believe the confusion is that there was an add-on calendar, so he's no longer positions 3 and 4.
Okay, sorry about that.
He's been bumped down.
Okay, yeah. Sorry, Deputy, we just had a revised calendar, so I was a little confused. Sebastian Raphael Smith, could you please raise your right hand? Okay, thank you. I just want to make sure I'm addressing the correct individual. You may put your hand down, sir. Mr. Sebastian Smith is case 23 CR 6433D on our updated probation revocation calendar. He was convicted of loitering and prowling and or willful obstruction of an officer. There's a probation revocation matter that's referenced as 24 PV 757. Mr. Smith, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Ms. Vigiletti is representing you. Ms. Allen is our probation officer. Why are we seeking a revocation of Mr. Smith?
Your Honor, the defendant was required to report to our office as well as complete 30 community service hours and pay probation supervision fees. The defendant has failed to provide documentation of the 30 hours of community service. I received information that Mr. Smith is currently homeless. At this time, probation asks that his case be time served. He's been in custody since May 1st.
So he's been in custody for 8 days?
Yes, Your Honor.
All right. Ms. Vigilante?
Yes, Judge, as Officer Allen said, Mr. Smith has been homeless. We made a plan together yesterday. His intention when he leaves here is to do a walk-in intake at Gateway. There had been an issue before with an ID, but a church has recently helped him get a birth certificate. So he'll be able to walk in at Gateway, and I think he knows exactly where he's going. So we would happily accept a time served recommendation this morning.
Mr. Smith, this is going to be recorded on your record as a probation violation, and I'll accept the recommendation. In lieu of the 30 hours community service, your time at the jail is going to be commuted to time served, and that concludes this case. Thank you.
Thank you, Judge.
ACDC, who do you have on our, oh, this is Juan Carlton. Ms. Vigilante, have you had a chance to speak with him?
I believe Mr. McLean will be taking this case, Judge.
Okay. This is Juan Carlton, convicted of simple battery, family violence, and/or willful obstruction of an officer. Case number 22 CR 004929J. Mr. Carlton's got a probation revocation matter 24 PV 597. Mr. Carlton, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Ms. Allen is our probation officer. Why are we seeking a revocation?
Your Honor, the defendant was required to report to our office complete domestic violence counseling as well as 40 hours of community service. The defendant has been in custody since April 8th, 2024. He has failed to provide our office with the completion of the domestic violence course. At this time, probation recommends that his balance be revoked 60 days, credit for the 30 days he's already served.
Mr. McLean?
We have a query as to whether that would cause time served at this date or whether that would be likely 30 extra.
I'm going to give him the full ratio balance. So if he's been in custody for 30 days, that will be deemed to be 60 days, and then it will be closing out the case.
I think that's probably non-objectionable to my client. I was about to get a couple of character witnesses to zoom in, Your Honor, but I think with time served on that and close out the case, I think that he's amenable.
All right. Mr. Juan Carlton, basically this will be recorded as a probation violation on your record for failure to complete the terms of your sentence. You have already been in custody for 30 days. I'll give you a credit of 2 for 1, so that will be a completion of 60 days. And your obligations for this case are over. Would you like to accept that, or would you like to challenge the probation violation?
No, ma'am, I would accept. Yes, ma'am.
This is recorded as a probation violation and is commuted to time served. Thank you.
Thank you.
ACDC, did you have any other cases? Okay, I think I heard that's it. Would you agree, Mr. McLean?
I think that's it for ACDC.
That's gonna be it anyway, Your Honor, because we gotta get these people out of the courtroom too.
Yes, sir. I hear you. Oh, who do you have?
I got
for today. Thank you.
Position number 7 and position number 8.
Okay.
Alfred Broughton.
Alfred Broughton has got 23 CR 5540C, accused of criminal trespass and possession and use of drug-related objects. His second case is 24 CR 913C, loitering and prowling. Mr. Broughton has been advised of his right to remain silent. His attorney is Ms. Vigilante. How are we proceeding?
Judge, it's my understanding that on the criminal trespass case, the solicitor's office is recommending a transfer to the DA's office. So we don't have a recommendation on that one.
All right, let me find out.
That is correct. That is correct, Your Honor. This case is interesting. There should have been a charge for possession of Schedule 2 added to it. Our office was waiting from the GBI for the test results, and we received those yesterday. So this case will be going up to the DA's office.
Has it been accepted? Has it been accepted by the DA's office?
Your Honor, it has not been accepted. As I stated, as Ms. Desiano stated, we sent it up yesterday evening when we received the results. So we are waiting for a response.
Case is reset to May 16th, 2024, pending a possible transfer.
And Judge, if you're agreeable to do so, there was an additional case where, and an offer was made on that case, and Mr. Broughton would like to accept the plea on that offer.
Is that on my calendar?
It is, yes. He has two cases. He's both positions 7 and 8. So position 7 is the very likely DA transfer, and position 8 is a loitering charge.
Okay.
On which Mr. Broughton would like to take a plea this morning.
All right, Mr. Broughton, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah.
All right. Ms. Desiano, what's the plea offer for position 8 only?
Yes, Your Honor, the plea offer for position 8 is 12 months probation, serve 4 days, credit for time served 2 days. That'll be from February 27th to February 28th of 2024, balance suspended, and a stay away from the 800 block of Myrtle Street in Atlanta. And at
And
this time, I'd ask the defense to stipulate to venue, factual basis, and ID for purposes of the plea.
So stipulated.
Mr. Broughton, have you consumed any medicine or alcohol?
No.
And have you understood the proceedings so far?
Yeah.
Are you satisfied with your attorney?
Yeah.
And is anyone forcing you to plead guilty to this charge today?
No.
If you decide to plead guilty, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the assistance of counsel to come back to court, confront your accuser, challenge the evidence brought against you, present any defenses or arguments if you choose to do so, and have the state carry its burden and prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yeah.
How do you plead to one count of loitering or prowling?
Guilty.
I'm sorry, could you please look up and what did you just say?
Guilty.
I'll accept your guilty plea. Your sentence is 12 months to serve 4 days, credit for time served 2 days, balance suspended, and to stay away from the 800 block of Myrtle Street, Atlanta, Georgia. If you return to that location, you will be arrested again. In the meantime, your other case, position 7, is going to be reset to May 16th, pending a possible transfer to Superior Court. Thank you.
Thank you, Judge.
Next, we're gonna go to position number 34, Mr. Winters, position 34.
Jaquarius Winters is accused of theft by taking and criminal trespass in case 24 CR 2354E. Mr. Winters has been advised of his right to remain silent, and his attorney is Ms. Vigiletti. Ms. Vigiletti, with regards to this case, how are we proceeding?
Judge, may I just mute for 1 second just to speak with Mr. Winters again briefly?
All right, are we ready to proceed?
Yes, Judge, Mr. Winters would like to enter a plea this morning.
What kind of plea?
I believe as negotiated.
Okay. Mr. Winters, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Falk?
Yes, Your Honor. State's recommendation is 12 months probation, 30 days, credit for time served, 15 days. That's going to be from April 26th of 2024 until today. Balance probated, 40 hours of community service and anti-theft course. Stay away from 130 Creekmont Way in Roswell, Georgia, and no further contact with Shannon Littlefield. Count 2 is 12 months concurrent to count 1. We would like to sound for Ms. Shannon Littlefield, and we would ask the defense stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
Ms. Vigilante, do you so stipulate?
We do, Your Honor, and we did want to bring to the court's attention, Mr. Winters did recently have a significant house fire, so significant that the Red Cross is working with them, but he is still living in the house with his partner. He does have a couple of kids, and you know, he does work, he works in lawn care, but they're facing significant expenses right now. So if the court would consider assisting Mr. Winter with fees, we'd greatly appreciate it.
So this is middle of May. I will waive his probation fees for the month of May and June. He will need to start paying probation fees from July 1st, 2024.
Okay, thank you, Judge.
All right, are we ready to proceed?
Yes, Your Honor.
Okay. Mr. Winters, have you consumed any medicine or alcohol?
No, Your Honor.
And have you understood the proceedings so far?
Yes, Your Honor.
And are you satisfied with your legal services?
Yes, Your Honor.
If you decide to enter this plea to theft by taking and criminal trespass, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the opportunity to go back to court with your attorney to challenge to confront your accuser, challenge the evidence brought before you, present your defenses and arguments, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
Are you entering this plea freely, willingly, and knowingly?
Yes, Your Honor.
How do you plead to 1 count of theft by taking and 1 count of criminal trespass?
Guilty.
Your sentence on the theft by taking is 12 months to serve 30 days, credit for time served 15 days. Your jail time is concluded. If you have no other holds at the jail, you will report to probation next Monday, May 13th, 2024, before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. I will waive your probation fees for the months of May and June, but you will start paying probation fees from July 1st, 2024 onwards. While you're on probation, you will complete 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. You will begin with a minimum of 5 hours in the first 30 days and then complete a minimum of 5 hours every month thereafter until your 40 hours are completed. You will also enroll in an anti-theft course, and you must enroll in that class within 60 days of being released. At all times, you are to stay away from 130 Creekmont Way in Roswell, Georgia. You're not allowed to return to that location, and you are to have no contact with Shannon Littlefield. Any questions? Oh, I'm sorry. And the criminal trespass, that will be 12 months concurrent to count 1. Any questions, Mr. Winters?
No, Your Honor.
All right, that concludes this case. Thank you.
Thank you, Your Honor. Position number 1, Anderson.
Your Honor, may I interject while we're between cases?
Yes.
On Mr. Dumas, let's see, what position was that?
Yeah, the one I've reset to, position, 13 and 14, yes.
There we go. Could I ask, what was the date of the failure to make court I've gotten on the internet for the Department of Corrections of the state of Georgia. And within recent history, I can go back if more is necessary, between October 26th of the year 2021 until May 2nd, a few days ago, he was in the state prison. So I need to find out what court date he missed because
I've got September 22nd, 2022.
well, that would definitely be in this time period.
Okay,
He was in state custody.
all right,
I
so,
don't know if I can print that out, but when I get to the office, I can print it out.
all right, we will address it then. Right now, we have DeMarcus Anderson, case 17 CR 17720H. Mr. Anderson has been accused of giving false information to an officer on December 29th, 2015. I understand that the case was null prossed on May 7th, 2024. Would that be correct?
That's
Yes,
correct.
and I just didn't get a chance to see Mr. Anderson to let him know yesterday, which is why I did not, waive bringing him today. Mr. Anderson, this case was dropped from 2015. When I came to see you and you had no memory of the case, it's been dismissed now, okay?
I'm sorry, medical, please unmute. Mr. Anderson, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Ms. Vigiletti is your counsel. Your counsel, as well as the court, has announced that the prosecution have decided not to pursue this case, so they have closed the case out.
Okay.
All right, thank you.
Next, Your Honor, we got position 28, position 29, position 30, and position 31. Mr. Alante Waters.
All right, got it. Thank you. All right. Alante Waters has 4 different matters before the court today. Position 28 is 2 charges of simple battery. One is simple battery family violence under 23 CR 1022F. Position 29 is a bench warrant from April 5th, 2024. And case number 24 FTA 514. Position 30 is a bench warrant, case number 24 FTA 515 from April 5th, 2024. And position 31 is the underlying case for charge of battery family violence from March 28th, 2021. And case number is 21 CR 1494F. Mr. Waters, you have been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Ms. Vigiletti, how are we proceeding with regards to, I understand he's entering a not guilty plea and seeking a bond modification. Would that be correct?
Yes, Judge, based on some information I learned about the failure to appear from April 5th.
All right. So, are you filing a waiver of arraignment for positions 28 and 31?
I'm happy to do so.
All right, let's address the bench warrants then.
Yes, Your Honor. When I went to speak with Mr. Waters yesterday, he explained that when he was in custody this past December, he did update his address with the jail, and it appears that never made it into the system. I see the address is updated this most recent time in May, but he had already moved and gave his updated address, the current address that you see, this 6.
How was that transmitted to the clerk's office?
He said he gave it to the jail, Your Honor. When he was booked in, he gave them an updated, and so it's my understanding that once it's updated in Odyssey, it is updated.
All right, let's see. I have a 1220 Gun Club Road. Was that the address he gave when he was at the jail?
For Mr. Waters?
Oh, I'm sorry, I'm on the wrong. I've got multiple windows open. Sorry about that. Let me get to close up these windows. Get to the SAP. All right, let's go to 28. All right. Sorry, I have a Myrtle Drive, 1867, and then have an update to 679 Smith Street. So which one was the updated address prior to this one?
Yes, Judge. So, Mr. Waters is telling me when he was in custody in December, he provided the 679 Smith Street address, but it seems to not have actually been entered into our system until May. And so I do believe that's why the notice went to the previous address, the 1867 Myrtle Drive.
All right. Looking at the jail notes, it says reset SAP, bond set by Judge Morrow. Emergency contact, it's Lakeisha Waters.
And she is here this morning, Your Honor.
All right. Documents. The allegation of the incident was at 679 Smith Street. Okay. He was, and you said it was in December?
Yes, he was in custody this past December.
Okay, I just need to pull up the case when he was in custody. What was the case? Was that from the?
Yes, Judge. So there is I'm not sure if you're looking at his page, if you go to jailings, he was booked in.
No, I know, but what I'm trying to figure out is whether the bond order required him to stay away from 679 Smith Street. And thereby he failed to update the court with his new address thereafter.
It did, Your Honor. If you look at the bond order on case number 23 CR 008003F, that was signed by Judge Morrow on December 15th of 2023. No further contact with Lakeisha Waters. Stay away from 679 Smith Street Southwest. May return one time with law enforcement to get belongings.
That's what happened. So, Ms. Vigilante, it was not a question of him updating the court of his new address. He did give his correct address at the time he was arrested, but after the stay away, he was required to update us with his new address since he couldn't go back to Smith Street.
Understood, Judge.
All right. So are we still proceeding with the not guilty?
I do believe I need to speak with Mr. Waters for a moment.
Can we take your next case first and hold off on this?
Certainly.
And Your Honor, actually, I would like to just make an announcement. There are 3 cases that belong to Mr. Waters. Only 2 of them are on the calendar. So we are missing 21 CR 00149-4F. So the state is going to withdraw their offer until we can give a global recommendation on all 3 of his open cases, not just the 2. And all of them involve family violence.
All right.
Thank you, Ms. Fall. Can you give me that case number again?
It is 21 CR 001494F. And I do apologize for missing this one in the group of cases.
In that case, Ms. Vigilante, we're going to reset all 3 cases to May 16th. All 5 cases, excuse me. All 5 cases.
Okay. Thank you, Judge.
Mm-hmm.
Position number 9.
And position number 9, Tyler Cornish Dukes. Could you please raise your right hand? Thank you. Just want to be sure that you were the person. Mr. Cornish Dukes, my name is Judge Law. You can put your hand up. My name is Judge Lal, and we are addressing your case 24 CR 2243, in which you are accused of simple assault and terroristic threats and acts from April 23rd, 2024. Mr. Cornish Dukes, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigiletti. Ms. Vigiletti, I understand your client is entering a not guilty plea. Would that be correct?
Yes, Your Honor, and Mr. Cornish Dukes would like to make a bond request this morning.
All right. Are you filing a waiver of arraignment?
I am happy to do so.
All right. Mr. Cornish Dukes, your attorney is going to file what we call a waiver of arraignment and enter a not guilty plea on your behalf, and your case is going to be further noticed for trial. In the meantime, your bond was set at $3,000 as a surety bond on April 25th, 2024. And why are we seeking a modification?
Yes, Your Honor, I have learned since his bond was initially set that Mr. Dukes intends to live with his father and his uncle. His uncle Neil is here with us today. Sir, if you wouldn't mind unmuting your video. He is living with them. He's going to be living with them in Florida, where they are going to put him to work. He is going to be working in both concrete and lawn care. Neil owns the lawn care business, and so he'll be busy and productive during this time. His father and uncle will make sure he makes it to future court dates on this incident, and I think because they're going to be keeping him so busy, we will not have to worry about danger to the community. It's my understanding that Mr. Cornish Dukes has not been in trouble since he was 18. He is 25 now. So we are requesting a bond reduction this morning so that he can get to work and be productive while he is awaiting further hearings on this case.
Uncle Leo? I don't see anyone, Ms. Vigiletti.
Judge Neil, if you see Neil is listed here,
Neil, is that his name? Neil or Leo? I can't.
Neil, I'm sorry. Neal.
Mr. Neil?
Yes, ma'am.
You need to start your video, sir, in order for us to address you.
I'm sorry.
Your video, we cannot see you.
I'm trying to get it active now. My apologies.
The host, could you please prompt Neil to start video? We can send you a prompt, sir. All right. Ms. Vigiletti, we seem to be having connection issues with Neil. Anything else?
I apologize, Judge. Unless you have additional questions for him, I believe that I've covered our request this morning.
All right. Ms. Desiano?
Your Honor, if I may just give a brief factual basis in this matter. This incident occurred April 23rd of 2024. Officers were called to a Greyhound bus at the intersection of Ted Turner Drive and Marietta Street in reference to a dispute. When the officer arrived, he was told by the victim that the defendant was being loud, drinking, smoking on the bus. He told him to be quiet. Wasn't quiet. Then he told him to shut the F up. And the defendant took out a handgun, cocked it, and said, "I will put holes in you." Your Honor, his history, it appears he's a resident of New York. His ID is a New York address. All of his priors are in the state of New York, and this would be his third arrest. And his prior two arrests, Judge, are the same thing: assault with and criminal possession of a weapon. So at this point, Your Honor, the bond is currently set at $3,000 surety bond. He has no ties to the community here in Atlanta. He's a danger to the community. This is the third time he's pulled a gun on a random person, and his risk of reoffense is high. So the state would object to a reduction in bond. And the fact that he's now possibly going to another state, there's no way to guarantee that he will come back to court here in Fulton County. He has no ties here.
Understood. Thank you. All right. Yes, I do see Mr. Neil has, Mr. Neil, if you could please unmute.
Yes, ma'am.
Is this your first time using Zoom?
It is.
All right.
It is. Yes, ma'am.
You're doing pretty good. All right, sir. Please raise your right hand and remove your hat. Thank you. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. How do you know Mr. Tyler Cornish Dukes?
He is my brother's son.
All right. And when was the last time you saw him?
Like in 2009, 2010. He was actually on his way down here to come live with us and start working with us.
My goodness. What a brief intermission. Okay. And what would you like to tell the court?
Just that, he was coming down here to get a new start, Your Honor. And I was going to put him to work with me on a landscaping company. I was hoping this case was going to get resolved today, but obviously that's not going to be the case. The issue is with the bond is we don't know anyone that lives in the state of Georgia that can sign the bond. All the bondmen that we have spoke to have said someone that lives in the state of Georgia has to sign the bond. That's the real issue on our end.
Understood. The other alternative is to put up a $3,000 cash bond. And if the case gets resolved in Mr. Cornish Duke's favor, then the cash bond will be returned to whoever puts it up, less a small administrative fee.
Yes, ma'am. That was never explained to us. So I mean that definitely would be an option.
Okay. I can amend the bond order to a $1,500 cash bond.
That would be excellent. Thank you.
Thank you, Judge.
And in addition to that, Mr. Cornish Dukes is going to be released to the custody. Mr. Neal, is your last name Cornish Dukes as well?
It's Dukes.
Just Dukes, all right.
Yes,
Mr.
ma'am.
Dukes, you would have to come up to Wright Street Jail so that Mr. Cornish Dukes will be released to your custody. He's not allowed to use Greyhound.
Yes.
So unless you want to send him a plane ticket, or you want to send him the ability to rent a car, he's not allowed to use the Greyhound buses to transport himself.
No, yes, ma'am. I'm going to come get him.
All right. So it'll be a $1,500 cash bond, which will be put up by a family member, including Mr. Neal Dukes. And Mr. Tyler Cornish Dukes is to stay away from all Greyhound buses and Greyhound stations. He's not allowed to own any firearms and be in possession of any firearms. So Mr. Neal Dukes, if you own any firearms, please make sure that they are secured and away from Mr. Tyler Cornish Dukes. If he's in possession of a firearm, he might find himself back in jail. And the
Yes, ma'am.
$1,500 cash bond forfeited.
Yes, ma'am.
All right. He's to not to consume any alcohol, no illegal drugs, and he's to maintain a current mailing address with the court at all times. So since the New York address is useless to us right now, as soon as he settles down in Florida, he needs to make sure he sends us a valid mailing address. Perhaps Mr. Neal Dukes, you'll be able to do that when you come pick him up at the Wright Street Jail. Make sure that his address
Yes, ma'am.
with the court system is updated. Because if he doesn't come back to court when summoned, a bench warrant will be issued for his arrest. And that tends to go nationwide. And that $1,500 cash bond will be forfeited again.
Yes, ma'am. Can you give me the address of that jail again, please?
I forgot the street number, but it's Rice Street, Atlanta, Georgia.
901 Rice,
That's
RIC.
what it was. That's what. 901 Rice Street Jail. Thank you, Deputy.
And Mr. Dukes, the number I called you from is my cell phone. So if you have any questions getting up here, let me know, okay?
Okay, yes, ma'am.
Cornish
Thank you.
Dukes, don't forget to come back to court when summoned. Thank you. Anything else, Mr. Dukes? Mr. Neil Dukes?
No, ma'am.
All right.
No, ma'am, that's it.
Thank you.
Judge, can you
Thank
give me
you.
the breakdown for that? And will this be reset to the 16 just in case?
Okay. Yes, on the simple assault is going to be 750. On the terroristic threats and acts is going to be 1,250, cash bond only. Release to, was that good?
I believe you said 1,500.
1,500.
Yeah, did I? Okay, so sorry, so I messed up. So it's 1,000 on the terroristic threats and 250 on the 500 on the simple assault. Sorry about that.
Next, we will go to position.
I'm sorry, just briefly, Mr. Cornish Dukes is also pleading not guilty this week, so if his.
Yes, I've got your waiver of arraignment down for that.
Okay.
Okay, all right. Thank you.
Next, we will go to position 15 and 16.
Yep, clear.
Mr. Greer. Thank you, both.
Alcaro Greer is accused of criminal trespass under 24 CR 2351H and also accused, and that was from February 12th, 2024. And then he's got a second case, 24 CR 2355H from April 25th, 2024, accused of terroristic threats and acts, criminal trespass, and willful obstruction of a law enforcement officer. Mr. Greer, you've been advised of your right to remain silent. Your attorney is Mr. McLean. And with regards to Greer, this is going to be a non-negotiated plea. Would that be correct?
Yes, Your Honor, the only issue being the extra jail days.
Okay. Mr. Greer, for purposes of plea, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Desiano?
I'm sorry, I'm muted. Your Honor, this incident, the first incident, 24 CR 2351, occurred on February 12th of 2024. Officers responded to Marquee Midtown Apartments at 415 Armour Drive, specifically to Unit 6202. Upon arrival, they met with the property manager who advised that they've had issues with someone going into one of the vacant apartments. At this apartment, 6202, the police did find the defendant sleeping in the apartment that was vacant. The property manager stated that he's had to change the locks and he's had 3 encounters with this individual and been asked not to return, and the defendant was subsequently arrested. The second case, 24 CR 355H, occurred April 25th, 2024. Officers were dispatched to the core at Lindbergh Apartments located at 741 Morosco Drive in reference to a trespasser. Upon arrival, they made contact with the apartment manager, Miss Keontae Jenkins, who stated that she needed someone removed from the area because he had all of his things spread out. The defendant was later identified as that male and he refused to leave. He said that to the property manager, "I'm not going to leave. You're going to lose your job and I'm going to F you up." The officer eventually had to tase the defendant to get him to leave off the property. And that's the basis for the charges. Your Honor, do you want the plea recommendation?
I believe it's time served on position 15 and there's additional 15 days plus no contact with Ms. Jenkins, 8-week anger management.
Yes, Your Honor. And the reason for the extra days, of course, is because of the terroristic threats.
All right. And what's the remaining on counts 2 and 3?
I'm sorry, what?
On counts 2 and 3 on position 16, what's the remainder of the plea?
Count 2 is 12 months probation concurrent with count 1, stay away from core at Lindbergh Apartments. And count 3 is 12 months probation concurrent with count 1 and the $300 fine.
All right, thank you. And I gather the other ones stay away from the Marquee Midtown Apartments. All right, thank you. Mr. McLean?
Your Honor, he had no qualms with any of the conditions, but the extra time in jail, he wondered based on his record and realizing what he's accused of, with his guilty plea taking responsibility, he wondered if the court could see its way clear to letting him go out tonight and go to a shelter such as Gateway at 256 Briar or the Baptist Rescue Mission on Peters Street, something like that.
All right. Ms. Tyson, what is Mr. Greer's history?
He has 12 arrest cycles beginning in 2014. He has a felony conviction out of Fulton County for burglary in the first degree. He received first offender treatment on that case February of 2020, and he received 5 years probation on that case. He has an FTA from 2019, 2020, 2021, and 2022. And it looks like he has a total of, looks like he has one violation of probation. Yeah, I'm sorry, 2 violations of probation. And his last arrest was in Atlanta for criminal trespass and criminal damage to property in the second degree. Looks like the case was dismissed November of 2023.
Okay.
Nothing to add, Your Honor.
So when was he convicted of the burglary? February of 2020?
Yes, February of 2020. Yes.
So,
And he received 5 years probation on that case.
all right, and these arrests occurred while he was on felony probation.
Yes.
Your Honor.
Okay. All right, anything else, Mr. McLean?
Nothing to add, Your Honor. Thank you.
All right. With all due respect, based on Mr. Greer's record, I'm accepting the state's recommendation that he serve an additional 15 days at the Fulton County Jail with regards to position 16. Would he like to move forward with the plea, or would he like to request a trial?
My understanding is we're moving forward with the plea nonetheless. Is that correct?
That's correct.
Yes, it is.
All right. Mr. Greer, in that case, Mr. McLean, do you stipulate to the factual basis, venue, and ID for both cases?
For the purposes of the plea, we do so stipulate.
All right. Mr. Greer, I need to make sure that if you decide to enter a guilty plea to these charges, that you're doing so freely, willingly, and knowingly. If I find in my discussion with you that that you are simply entering this plea to get out of jail and that you pose a very high likelihood to reoffend, I'm not going to accept this plea because I have a right to do so, and I'm just going to continue this case to trial. Do you understand, sir? So if you plan to be forthright and honest with me, I'll give you the opportunity to take this plea. But if I find in any way that you're being evasive or not forthright, and I know I'm doing this via Zoom, but some reason I can tell. Do you understand?
Yes, ma'am.
All right. Have you consumed any medicine or alcohol?
No, ma'am, I haven't.
And have you understood the proceedings so far?
Yes, ma'am, I do.
I'm sorry?
Yes, ma'am, I do.
And are you satisfied with your attorney?
Yes, ma'am, I am.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am, I am.
And if you decide to enter into this plea, you would have to give up your constitutional right to challenge these charges in a court of law. You
Yes,
will
ma'am.
not have your attorney with you to go back to court, to challenge the charges brought against you, to be able to testify and confront your accuser, to be able to confront your accuser, to be able to challenge the evidence brought before you, to be able to present your arguments, your defenses, your mitigating factors if you choose to do so, and also have the prosecution carry its burden and prove the charges against you beyond a reasonable doubt. Are you?
I'm for him a copy of what Your Honor is reading.
I'm sorry?
I'm just grabbing a copy of what Your Honor is telling him so he can see it in writing as well.
Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass at the Marquee Midtown Apartments?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days, balance suspended. If you are seen within 200 yards of the entire Marquee Midtown Apartments at 415 Armour Drive in Northeast Atlanta, you will be arrested again. Staying away from the entire apartment complex means the length of 2 football fields. Do you understand that, sir?
Yes, yes, ma'am, I do.
How do you plead to 1 count of terroristic threats and acts, criminal trespass, and willful obstruction of a law enforcement officer?
Yes, ma'am, I'm guilty.
On the terroristic threats and acts, your sentence is 12 months to serve 60 days, credit for time served 15 days, balance probated. You will report to probation on Monday before 3 p.m. at 132 Mitchell Street. While you're on probation, you are to stay away from the core at Lindbergh Apartments at 741 Morosco Drive in Atlanta, Georgia. Again, you have to stay at least 200 yards away from the entire apartment complex. You are to also enroll and complete an 8-week anger management program. You must enroll in that program within 60 days of being released. Failure to comply can result in your probation being revoked and you being back in jail to serve out the rest of the year. On count 2, criminal trespass is 12 months concurrent with count 1. And the same, stay away from the core at Lindbergh Apartments and no contact with Keona Jenkins. Count 3, with regard to the willful obstruction, is 12 months probation concurrent with count 1 and a $300 statutory fine. You will begin paying that fine with a minimum of $25 in the first month, and then a minimum of $25 every month thereafter until the entire $300 is paid off. You will report to probation every month, and if you get arrested again, probation is authorized to revoke this probation and to have you serve out the rest of the time in jail. Thank you.
Your Honor, for the record, if we could sound for Ms. Keontae Johnson in accordance with Marcy's law.
Ms. Keontae Jenkins.
Jenkins, I'm sorry.
Yeah, she's not here. Thank you.
Position number 25 and 26, Phillips.
Is that the gentleman at medical?
Yes.
Thank you. Marcus Phillips has got 2 cases with us, 24 CR 2712G, accused of battery from February 7th of this year. And the second case is 24 CR 2713G, giving false information to an officer and battery family violence from April 17th, 2024. Mr. Phillips, you've been advised you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. McLean. Mr. McLean, I understand your client intends to enter a not guilty plea. Will you be filing a waiver of arraignment?
Yes, Your Honor. That's not guilty on both and a bond request.
All right. And so this case is going to be a waiver of arraignment, both cases, sorry.
Correct.
And they're both going to be further notice for trial. Sorry, excuse me. Come on. Okay. Mr. Phillips presently has well, I'm not sure, the bond order is not on file, so let me see. He presently has a $12,500 bond and a probation hold. Yes, Mr. McLean?
He believes the probation hold will be satisfied, will be taken care of within the next week. And so he believes that it would be accurate to say the bond, even on this misdemeanor, is not at this time moot. Your Honor, he saw that when his case was bound over from one point to another, he had bonds that were approximately, he was telling me about, they were approximately half of what they are now. And he's going to do his best to talk to relatives to make them But even if the court were to agree to with him that it would be fair to have bonds at half this amount, he still would be under quite a financial burden to make that. And that would be a powerful, powerful incentive for him to come back to court, even just on the financial, if not the moral aspect.
All right, and his probation violations are allegedly based on his new arrest in 2024. So, all right, I don't have any information about his original bonds from the originating court. So, Ms. Falk, do you have that information?
Yes, Your Honor. I'm attempting to see if I can find that information in the system. I'm guessing because of the timing of the case, that may be why we don't see a bond. It looks like he was, let's see. Well, no, it would have come in after the cyber incident. So I'm not sure. I will say it looks like both of these may have been, yes, bind over cases. So that's why. For the first bind over case, I'm showing he was given a bond in the amount of $7,500. So on the battery giving false name charge, the case was bound over with a $7,500 bond. On the second case, which is just one count of battery, the case was bound over with a $5,000 surety bond. Both of those were bound over from Union City Municipal Court.
All right, that's the information I have, Mr. McLean. Total bond is 12,500. I don't have a record that it should be 6,250.
Understood, Your Honor. He was thinking it doubled. He was thinking it was around 20,000 now or so. And so he was mistaken in that. But even at the level of 12,500, we would ask to make the point that a bond of 5,000 or 6,000 total, a bond of 7,000 total would still be sufficient to serve the public.
All right. Ms. Tyson, may I have Mr. Phillips' recent GCIC, including the case that he's on probation for?
The last arrest was February.
I'm sorry?
Yes, he has 10 arrest cycles beginning in 2011. He has a felony conviction out of Fulton County for possession of firearm or knife during the commission of aggravated assault and criminal attempt to commit a felony. He received first offender treatment on that case, October of 2020. And he received 15 years probation on that aggravated assault. And it looks like he has a possible pending case out of DeKalb County. 2 counts of trafficking a person, pimping person under 18 years of age, keeping a place of prostitution for person under 18 years of age, battery, contributing to delinquency of a dependency of a minor, 2 counts. Looks like the case was indicted October of 2022. No further information was provided. He has 2 violations of probation.
That's planned. Thank you.
Yes, Your Honor.
Ms. Falk, any comment on his current bond?
Yes, Your Honor. So we do have, we are asking the bond to remain as set. That case is still open in DeKalb County. The case number is, I'm actually looking at their information now, 22 CR 2631. That case, as I stated, is still open. He also has an additional case in DeKalb County, which is marked as, and just, Your Honor, could just give me a moment. Which is marked as, I believe it was 24. Let's see. Sorry, I had to get back into their system. 24 CR 1940. So there do appear to be two cases. Both are those serious felonies that were just listed by pretrial services on actually both cases. So he has two pending cases for those offenses, which show that there is, I mean, allegedly that he has committed new offenses while out on bond. Additionally, we are showing that he has a number of probation violations, one from 2018, theft by taking out of Clayton County from 2018. He's on that first offender.
That's enough. Those open cases were more than enough. Bond modification request denied. There's no error in the bond amount set. So we will further notice both cases for trial. Thank you.
I'll go back to him and explain that, Your Honor.
All right, thank you. I think he understood. All right, let's move on. Next case, please.
Position number 24, Mr. Ivan Parker.
Mr. Parker is number 24. He was on the calendar last week. The alleged victim is on screen, Your Honor.
Yes. This is Ivan Parker, case 23 CR 1103J. Mr. Parker is accused of a battery against a female who's pregnant and battery family violence from an incident of February 26, 2023. Mr. Parker, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean. Okay, and Mr. Parker, are we still proceeding with the plea, Mr. McLean?
Yes, Your Honor. We were in court last week and we had a change of mind and asked for it to be put back on the calendar to accept the negotiated plea.
All right. Please raise your right hand, Mr. Parker. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. You may put your hand down. Ms. Folk, what's the plea recommendation?
Yes, Your Honor. Count 1 would merge with count 2. Count 2 will be 12 months to serve 34 days. Credit for time served 17 days. That's going to be from 2/26 to 2/28 of 2023 and April 22nd, 2024 to today. Balance probated. Family Violence Intervention Program. 40 hours of community service, no further contact with LaJoy James, and stay away from 2065 Ivy Lane, as well as no firearms. Ms. James, as you know, is present here on the Zoom. We did have an opportunity to speak with her, and she did agree with the plea when we last spoke with her. So we would like to sound for Ms. LaJoy James in case she wishes to make a statement, and we would ask the defense to stipulate to venue factual basis and identification for the purposes of the plea. That's all for the state.
For those purposes, we do so stipulate.
Ms. LaJoy James, you are on Zoom. If you would like to contribute to the proceedings, you can unmute and start your video. Otherwise, we are going to proceed without you. Ms. LaJoy James.
I don't have anything to add, Your Honor.
All right, thank you. I'll respect that. You may mute your screen. Thank you. All right, Mr. McLean, shall I proceed with the plea?
Yes, Your Honor. The only point would be that Ivy Lane is not associated with Ms. James. It's associated with his family. She's out of state, I believe, so there wouldn't be a need for that element.
Ms. Falk, have you confirmed that 2065 Ivy Lane is not Ms. James' residence, or?
If I may ask, Ms. James, is the Ivy Lane address your residence, or do you, not your residence? Let me ask that a different way. Do you currently live at that address, or is that the defendant's address?
No, I was removed from the lease and I relocated back to California.
Okay. All right.
All
So
right.
she has relocated. Thank you, Ms. James.
So thank you, Your Honor. We will remove the stay away provision.
All right. Anything else, Mr. McLean?
That's it.
All right. Mr. Parker, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And I'm sorry?
Yes, ma'am.
And is anyone forcing you to enter this plea today?
No, ma'am.
If you decide to plead guilty to these charges, you will have a conviction for battery, family violence on your criminal history record. Any subsequent arrest for a similar offense will be a felony charge. Has that been explained to you? I'm sorry, you need to speak up, sir.
Yes, ma'am.
And are you still willing to move forward with this plea?
Yes, ma'am.
In order to accept this plea, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have a chance to go back to court with your attorney, to challenge the evidence brought against you, to confront your accuser, to present your defenses and arguments, and to have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery, family violence?
Guilty.
The charge of battery against a female who is pregnant merges with the battery, family violence. Your sentence to the battery, family violence is 12 months to serve 34 days. Credit for time served 17 days. Your jail time is concluded and you will be placed on probation. You will report to probation next Monday. Today is Thursday, so next Monday will be May 13th. You must report to 132 Mitchell Street in downtown Atlanta before 3 p.m. While you're on probation, you will complete 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. You will begin with completing 5 hours in the first 30 days and then minimum of 5 hours every month thereafter. You will enroll in a domestic violence intervention program within 45 days of being released. You must show proof of enrollment to your probation officer and continue with those classes without any legal breaks until it is completed. At all times, you're to have no contact with LaHoy or LaJoy James. You're to stay 200 yards away from her and not communicate with her in any way, form, or manner, including in person, mail, email, cell phone, computers, and social media. And at no time are you allowed to possess a firearm or be anywhere near a firearm. That concludes your sentence. Any questions?
No, ma'am.
All right, thank you.
We can go back to decision 13 and 14, Mr. Dumas.
All right, yes, Mr. McLean, we are addressing Reynard Dumas, who's been advised of his rights, 22 CR 4841J. Yes, sir.
Your Honor, with his not guilty, he was pointing out that the $1,000 surety bond that is holding him in jail is the only thing holding him in jail. And he would ask the court to convert that to a signature bond as on the date in question for the failure to appear. He was during that period of incarceration with the Georgia Department of Corrections, which I believe was October 26th of 21 through, well, up until he came to our jail a few days ago.
Is he being returned to the Department of Corrections?
You're not being returned. No, Your Honor, this is, he's not going back.
All right, Ms. Falk?
Your Honor, that's correct.
Oh, I'm sorry, Ms. Desiano?
That's correct. We did confirm that he was incarcerated during that time.
All right, we're going to set aside the bench warrant, and you would need to provide a proposed order, Mr. McLean. While this is still an open pending case, Mr. Dumas shall not operate any motor vehicle unless he has a valid driver's license, adequate insurance, and proper registration. And when I say a valid current driver's license, I don't mean a limited permit, and I don't mean a conditional permit like a CP. It has to be a Class C or a full-fledged CDL.
You understand? Okay, very good. Thank you.
All right, thank you. And this case is further notice for trial, position 13. Anything else, anything else in courtroom 2?
That's it.
No.
All right. Is Mr. Kevin Cook present?
Yeah.
That is our DV bench warrant. Mr. McLean or Ms. Vigiletti? Were you in contact with this individual?
We have not yet been in contact with Mr. Cook.
All right, Mr. Cook's case is 10 CR 358065, scheduled on the DV set aside bench warrant. Kevin Cook.
Your Honor, now that we have a moment to breathe, if I could grab the Odyssey, I would try to any phone numbers I see on there.
Okay, on Kevin Cook, I'm going to actually, Mr. McLean, I'm going to go over the calendar. So on the bench warrant matter, since Mr. Cook has not appeared and it's already almost noon, the request to set aside the bench warrants denied. Okay, just to go over the calendar, on the DB bench warrant, that's a denied. On the probation calendar, Ms. Vigiletti or Mr. McLean, are you all there? Okay. On the probation calendar, position 1 and 2 is commuted to time served. Position 3, probation's revoked. She has 57 more days to serve at the jail. Position 5 and 6, Carlton Hall, has not been addressed. Medical, who do we have? Okay, Carlton Hall has not been addressed. Position 7 and 8, Smith, is commuted to time served. Position 9 and 10, Tittle, is commuted to time served. So the only case that we're waiting on probation is Carlton Hall.
Probation 1 and 2, Mr. Hall is ready.
Oh, just like magic. Okay. This is Carlton Hall at the medical unit. Who's representing him?
I do, Your Honor.
All right.
This will be pretty straightforward and brief as I understand it.
All right. Mr. Carlton Hall's case is 22 CR 51298. He was convicted of battery and or simple assault. And he's got a probation revocation matter, 24 PV 756. Mr. Hall, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. Michael McLean. Our probation officer, Ms. Allen, has been sworn. Why are we seeking a revocation, Ms. Allen?
Your Honor, he was required to complete 6 weeks of anger management and have no contact with the victim. The defendant has failed to provide our office with proof of completion. He actually has been in custody since May 1st, 2024. It is 45 days remaining on his case. At this time, probation recommends that his case be time served.
Mr. McLean, does your client acknowledge the violation and the case is commuted to time served?
Yes, Your Honor, he does.
All right. Mr. Hall, we're going to give you credit for the time that you've been in jail. It's commuted to time served. Your obligation for this case is over. And that closes the matter. Thank you.
Your
So-
Honor, that concludes my business.
Thank you,
May I be
Ms. Allen.
excused?
Yes.
All right, thank you.
Thank you. All right, so that concludes the probation calendar. On the bench warrant, I've already announced that. Oh, excuse me. The all-purpose add-on calendar, positions 1 through 4 are is a not guilty plea and further notice for trial. Position 5, Tiffany Hendricks, a signature bond is granted and it's a further notice for trial. All right. On the all-purpose calendar, position 1 was null cross. Positions 2 and 3 are reset to May 16. Position 4 is transferred to Superior Court, reset to May 16 pending the transfer. Position 5 is a $3,000 signature bond through pretrial. Position 6, the bench warrant is set aside. Position 7 and is reset to May 16. It's been transferred, pending a transfer to Superior Court. Position 8, same individual, was a plea. Position 9 is a bond is amended to a $1,500 cash bond. Reset to May 16, pending release to Mrs. Uncle Neil Dukes. Oh, no, I'm so sorry. For Tyler Cornish Dukes, there was a waiver of arraignment announced, and that case is further notice for trial. Not reset, it's further notice for trial. Position 10 and 11, Curry, we've not addressed that case. Oh, you're requesting a 1-week reset, so that's reset to May 16th.
Yes,
10
Your
and
Honor.
11 are reset to May 16th. Position 12 is released, so that's further notice for trial. Position 13 is a further notice for trial. 14, a Dumas bench warrant is set aside. 15, Greer and 16, Greer are pleas. 17, Harris is refused for interview or not interviewed.
Your Honor, for the 4th or 5th week in a row, we have not been able to get an interview done. Yesterday, it was not a matter of the deputy saying that he didn't come out of his cell, however. So maybe things are improving, but nonetheless, he did not appear in the visitation booth.
All right. How would the PD's office like to approach this case?
I'm going to talk further with our social workers about maybe he would listen to a social worker.
All right. It's reset to May 16th, pending a social worker visit. And on the alternative, Mr. McLean, you may have to be escorted to his jail cell to have a conversation.
Correct.
All right, so those are the options. Position 18 and 19, this is the waiver of arraignment and further notice for trial. Bond modification was denied. Position 20 in 20, 21, 22, and 23 are reset to May 16 so that Mr. Pack can have an understanding of his plea and then participate in his plea hearing meaningfully. Position 16, Ivan Parker is a plea. 25 and 26 are waiver of arraignments and further notice for trial. Bond modifications denied. 27, Santano was a plea. 28 and 29, Waters. Well, 28 through 31, those are all reset to May 16, including a 5th case, 21 CR 001-494F.
Your Honor, I did provide the wrong case number. I have updated it with the clerk's office, but the case number that is being added is 23 CR 008-003F.
And I have
Thank
it.
you,
Thank you, Ms. Falk.
Thank you. Okay, so all his 5 cases are going to be reset to May 16. 32 and 33, Mr. Wilson. Let's see, and that's, how would we like to proceed with Mr. Wilson?
Your Honor, we were not able to talk with him yesterday. He did not appear in the visitation booth. I don't know if it was a staffing problem or his problem. So I don't want to intimate that it was his problem. He has sometimes been in court, and cooperation can vary, and I'm hoping that he's having a good day.
Right, well, the offer right now is would have been released unless he's got any other holds. So, and is balance suspended. So hopefully he'll appear on May 14th. Let's reset his case to May 14th, SAP calendar. Positions 32 and 33.
I will have my fingers crossed on that one. Yes.
All right, sir. Position 34, Winters was a plea. All right, folks, that concludes the SAP calendars, probation calendars, and the bench warrant calendar. Anyone who is not connected to the 11 a.m. competency calendar, you're free to go. Miss Strong, if you could place me and Miss Falk, Mr. Dennis Murphy, Mr. Paul Bartel, Miss Kasha, and I don't see Miss Kia Burgess. Anyone else who needs to go into the breakout?
Good afternoon, Judge. Just to let you know, Ms. Burgess had a family matter to deal with, so she's not going to be here.
All right. So Miss Kasha and Mr. Bartel. So, all right. Thank you.
All right, if you got Zoom on your phone, punch that blue rectangle called Zoom. You know, we have that passcode. If you got a pencil, write down these following 11 digits, and then write down 6 more digits. The first 11 digits are the meeting ID. The next 6 digits are the passcode. Ready? 976 0365 8671.
Hello?
Just mute yourself until the judge come back.
Mr. Cook, you can't talk on the phone and be on Zoom at the same time, is that correct?
No, I can't. So I shared the link on my computer. So now it's on my computer.
The judge will want your explanation of why you missed court, why the notice didn't get to you. She's gonna recognize the fact that it is an old case, but that's not gonna necessarily win the day. There's got to be a logical explanation of what efforts you have made to stay in touch with the clerk.
Yeah. Okay.
So now that you're on the computer with the login, I can call your phone number and talk to you on the phone?
Well, lo and behold, Mr. Kevin Cook is present. All right, courtroom 2, by any chance, would, okay, Ms. Vigilante?
The guy in the back, they don't call it proper attorney.
Yes, Judge, I believe Mr. Cook and Mr. McLean just had a meeting, so I
All right.
they're ready to proceed.
All right, I'm gonna put a stay on my order to deny the set aside of the bench warrant. And so this is case 10 CR 358065, State versus Kevin Dwayne Cook, accused of simple battery. And he's got a failure to appear before Judge Myra Dixon on August 6, 2010, in this particular case. And since 2010, his case has been in a dormant status pending resolution of this matter. Okay, do we have a prosecutor? No, because we had canceled. So Miss Strong or Miss,
Yes, ma'am.
would you be able to reach out to
Ms. Falk?
Miss Falk? Yes, or Miss Desiano.
Okay.
And Mr. Cook, while we're waiting for the prosecutor, please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. And presently, Mr. Michael McLean is your appointed counsel. All right, Mr. McLean, we're just going to hold until Ms. Falk gets a chance to chime back in because we had concluded court after our last calendar.
Correct. Yes.
Yeah, I believe. Yeah, it's.
You can mute courtroom 2 until Ms. Falk appears, if that helps.
Thank you.
Judge Law, I reached out. I'm just waiting for a response.
All right, thank you. Oh, Miss Desiano, my.
Ms. Falk stated that she's in the waiting room, waiting to get in.
Okay, Miss Strong, if you'd please let. There we go. Miss Falk, I'm sorry, but Mr. Kevin Cook has made a late appearance.
All right.
And we are ready to proceed with his case. His case is from 2010. He failed to appear in court before Judge Dixon, and the case has remained in a bench warrant status dormant since then. So, Mr. McLean, your client has been advised of his rights. How would we like to proceed? I'm sorry, you're on mute, Mr. McLean?
There we go, I'm off mute. I would like to ask the court to consider leaving the case open with him having the bench warrant set aside for the time of the case. Your Honor, a brief explanation from either the state or from myself might help flesh out that request.
I'm not sure exactly what the state is explaining, so I would put this up to PD McLean to explain why he failed to appear on his bench warrant.
I'll cut to the chase. Here's what it's about. In 2009, this gentleman was the executive director of a house that was a rehab facility, and he resigned. And somebody appointed one of the residents to become the new executive director. Mr. Cook had his stuff boxed up, but he was going to the store to get some other boxes so he could move his stuff out of the room to which the new executive director was going to be entitled to live in. Apparently, the speed at which he was getting the new boxes was displeasing the other person. So he started taking his stuff and throwing it into the dirt in the yard, including nice things like a nice suit that he had to wear. He had resigned. He was moving to another address. The whole thing was silly and unfortunate, but it did take place in 2009. Apparently, the address to which the clerk has been trying to mail something ever since, probably ab initio, probably very much at the time in 2009 or 2010 or whenever. I don't know what that address was because I haven't been able to get on Odyssey, but he believes that he gave a correct address in, what was that town you mentioned? Riverdale. He believes he gave a good address in Riverdale so that he would get his good mail. But I don't know if the clerk is trying to send it to the incident address or to the Riverdale address. I don't have a good explanation right now as to why the mail didn't reach him back in 2010 or 11 or whenever that mail failed. But he's saying that he was in good faith, not trying to duck anything. He does say that in his not trying to duck anything, that he was calling a number for some time. We were conversing on the phone and I was about to ask him for how many months or how many years was he trying to talk to somebody on the phone to make sure he was keeping up with his court matter? And was that person at a bonding company or was that person at the clerk's office? So that's where we left it.
Ms. Falk, any objection to a set aside?
Yes, this case is 14 years old, and the address that we currently have on file is a 3230 Linden Garden Drive address in Atlanta, Georgia. This defendant has been essentially bench warranted since, let's see, it looks like August of 2010, and then the warrant was issued December 2010. And then there was a warrant FTA, it says 1 year rule. So I'm not even sure if the bond could even be reinstated at this point, given how old this is, and the bonding company would have been relieved of their surety at this point. I find it hard to believe that in 14 years, this defendant couldn't seem to make it to the courthouse and get his address updated and the information needed to appear here before now. And quite frankly, he didn't even appear at the time he was supposed to appear today. So I just have some serious concerns about how seriously he's taking all of this, given the length of time and the fact that I haven't heard any real reasoning for why he didn't appear for the last 14 years.
I was going to ask, what address was it to which the clerk attempted to mail something?
It is the address that we have on file, which it would have been the defendant's responsibility to change if it was incorrect, was 3230 Linden Garden Drive, Atlanta, Georgia, 30349.
Okay, Mr. Cook, can you explain this as far as when did you change the Linden Garden address and when did you inform anyone?
Please raise your right hand. And Mr. Cook, your audio is not connected. Your audio is not connected.
It should be.
Oh, there we go. All right. Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
All right. You didn't appear in court in 2010. Why?
Well, when I was released,
You need to speak up, sir, because there's a lot of noise in courtroom too.
when I was released back in 2009, they gave me a phone number to call to find out when my court appearance would be. And I would call that number periodically, once a week or once every 2 weeks.
That number was to whom? That number was to whom?
Court.
Which court?
Find out when.
Which court?
I can't remember, ma'am. I cannot remember which court. It was supposed to be the court that was handling my case.
Mr. McLean, could you please mute courtroom 2 because we are having great difficulty hearing Mr. Cook. All right. The court that's handling your case was, which court was
I
it?
assume that's what number it was. It's back in 2009. I can't remember that far back exactly the number or exactly who I was calling, but it was in reference to this case, finding out when I would have to appear before the judge.
Did
On
you
this
ever go
matter.
back to the courthouse to find out, since you were not getting
No,
the response?
What was told to me is that they don't see nothing. What initially happened is that they got the address, I mean, not the address, but my date of birth wrong. And so when I would
Oh,
tell her, I'm
let me
Kevin
interrupt you for just a second. Before you
Okay.
explain your answer, she asked you a yes or no question.
I'm sorry.
Okay.
Can you ask the question once again? Because I forgot it.
Did you ever go back to the courthouse where you had your case?
No, I did not.
All right. So why should I set aside a bench warrant for an open criminal case against you?
Because when I would put the number, they would tell me there's no trial or no court, no dates.
All
And
right.
each time they would say, well, we can't find you. Then they started, we can't even find you because somebody gave the wrong birthday for me when I don't know how they got it wrong because, it was on my ID, my real birthday.
All right. Anything else, Miss Falk?
Yes, Your Honor, I did misspeak. I'm showing that the defendant's original address that he was bench warranted on, because the system had already been updated with the address change, was 817 Winthrop Cove, apartment 817 in Riverdale, Georgia, 30274. That was where his notice was sent. It does not look like that information was ever updated. I will state that the incident where this happened appears to have been 308 Rhine Hill Road in Atlanta. So it was not the same location as where he was moving out of when all of this happened. It looks like the defendant was also considered for diversion, but rejected diversion. And so here we are 14 years later trying to untangle all of this. And again, it is the defendant's responsibility to at least show up once at the court to try to find out what's going on. If he lived in Atlanta this entire time, or even close to Atlanta this entire time, there's really no reason why he couldn't have shown up in 14 years to find out what was happening with his case.
And this is diversion through the Fulton County Prosecution's Office?
Yes, back in 2009, he was considered for diversion and rejected. So,
Okay. So he's been dealing with the state court. All right.
Your Honor, I think the rejection might be because of no response. Would that be the case?
I do.
It says he failed to show for his initial interview.
Right. So I don't think he came to a court and rejected it.
I don't know, Mr. McLean. I'm not about to speculate. Anything else for anyone wants to say before I make a ruling?
I did ask him if anybody has heard of this Gary person since then. He said the person who was in charge of the entire operation is Reverend, somebody who had the rehab facility and is now deceased. He is somewhat doubtful that there's any way to get hold of Gary.
All right. Anything else, Mr. Cook? What more do you want to add?
Yes, ma'am. I would just like to clarify to the prosecutor that I was living at 308 Rhine Hill. That's where I moved out of. So that was the incident. And I was moving to Riverdale. So I was only told to call a number. Nobody ever said, come down to the court and find out what's going on. And, I was only doing what I was told. And they said, just call this number. You will get a court date, and then you are supposed to appear on that court date. So I never.
Mr. Cook, how would the clerk's office know where to send the notice if you didn't update us with your new address?
I did give the new address in Riverdale. I gave that address.
Right. Riverdale is not the Fulton County State Court.
No, his address.
Yeah. No, he said he gave the address to the Riverdale court.
No, I think he gave the Riverdale address as where he was moving from Rhine Hill.
Okay.
And then later on, the garden address, I think that's the one he probably just changed a few minutes ago or a few days ago.
Ms. Falk, do you have any record of a change of address back? You're on mute.
Your Honor, there was the Riverdale address that was showing as part of his bond. Then May 3rd of this year, he changed it to the Linden Garden Drive address.
Okay.
I'm not seeing anything in the record that shows that he ever applied for an address change in between those two events, nor anything that shows mail was returned for a bad address.
All right. I don't know how the state's going to proceed with prosecution in this matter. I don't know if they plan to, but that's still an open case, and the entire decision to null pros the case or dead docket it is completely up to the prosecution. In the meantime, I'm going to set aside the bench warrant. Mr. Cook, this is an open active case against you disregarding the age. If you are ever mistaken, let me be very clear. Right now, it appears that Mr. McLean is representing you, but once they qualify you and they find that you do not qualify for their services, it's your job to either hire an attorney to represent you, or you can choose to represent yourself in the event that you do not qualify for the public defender's office. This is an open, active, and I hope you're writing this all down. This is an open, active case against you. It is with the State Court of Fulton County, and the judge who had the case in 2009 is still the judge who has the case against with respect to you, and that's Judge Myra Dixon. If you change your address, if you change your phone number, if you change your email, any kind of contact information, you're required to come down to the courthouse in person and file that in writing, so that is updated on the system. Simply calling on the phone to someone whom we cannot identify, we have no idea with whom you're communicating, results in you spending quality time with us with regards to a bench warrant for your arrest. I don't know how many people are comfortable with this, but I am not comfortable if I know there was an arrest warrant floating out there against me. So I'm just letting you know that in 2009, you knew you had an open, active criminal case, and it has been a serious lapse of judgment on your part on how you followed up with that case. Serious, serious lapse of judgment. So please remember, this is an open, active case, and you need to come to court when you're required to do so. You're free to go. Mr. McLean, will you send a proposed order setting aside the bench warrant? I'm sorry, Mr. Cook, you're free to go.
I'm on mute, sorry. Yes, Your Honor, the form I've got for that, the laptop, I don't know what it's doing right now, but I will go to the office and you should see that in an hour.
I'll do it. No worry about it.
Okay, excuse me, Judge, Ms. Falk and Mr. McLean.
Yes.
Yes.
Oh, just 1 minute. We have a Carlethia Wright on Zoom.
Okay.
Is that staff or?
I believe that's Cortez Wright's mother, if I am correct. Miss Wright, are you Cortez Wright's mother? Let me see if I can reach out.
That is her.
Okay. So, Miss Wright, your son's case has been dismissed per your request. So the only thing that he's left in custody on is his felony case. He is no longer he no longer has a misdemeanor case with us. So if you're free to go. Thank you so much.
All right. Ms. Strong, we can remove Ms. Carlethia Wright from Zoom, and we can pause the recording and the live stream. Does Ms. Falk need to remain on the Zoom?
Yes, and Mr. McLean.
All right. And pause the recording and live stream, please.
I'm doing it right now, Judge.
Thank you.